Good afternoon. Afternoon. Good. Welcome back to 23-11-02. We're here this afternoon for oral argument in this matter. I want to open oral arguments with the same reminder that we always provide, which is that the authority has read and reviewed the written exceptions filed thus far. And we ask that you focus your arguments on any salient points, as the oral arguments are an opportunity for the commissioners to provide or to ask questions, clarifying or otherwise, regarding the written exceptions that were filed. We do have up to 3 hours set aside for oral arguments this afternoon, which would bring us up to 4 p.m. I'm going to begin by taking appearances, and then we will go through in order of those who requested oral argument. But I will take appearances from any parties or interveners intending to participate in oral argument this afternoon. I see Attorney Venora.
From the firm Keegan Werlin. I'm joined today by Attorney Cheryl Kimball and Attorney Brendan Vaughn.
Thank you.
Thank you.
Attorney Wheel.
Good afternoon, Tom Wheel from the Office of Consumer Counsel. I'm joined by Consumer Counsel Claire Coleman.
Thank you.
Good afternoon, Thomas Lopez on behalf of the Office of Education, Outreach, and Enforcement, and I'm joined by my colleagues, Attorney Brittany Wyman and Attorney Alex Sahi. Thank you.
Thank you. Attorney Wright.
Good afternoon, John Wright on behalf of the Attorney General, and I'm joined here today with Caroline McCormick from the Attorney General's office as well.
Thank you. Attorney Lawn.
Thank you. I'm Shannon Lawn on behalf of Conservation Law Foundation.
Thank you. Are there any other attorneys representing parties or interveners that intend to participate in oral argument this afternoon? Okay. Seeing none, we'll begin oral argument in this matter. And we have the company. So Attorney Venora.
Thank you, Chairman Gillette. Attorney Kimball will be presenting the company's main argument.
Thank you.
Good afternoon. Can you hear me?
Can you hear?
Good afternoon, Chairman Gillette, Vice Chairman Bukowski, and Commissioner Karen. I am here today on behalf of Connecticut Natural Gas Corporation, CNG, and the Southern Connecticut Gas Company, SCG. Today, I have 3 areas to cover in relation to the draft decisions and our written exceptions. First, our concerns over the conduct of the proceeding and what it means for the draft decisions. Second, our concerns regarding the decisional framework that PURA is applying to these rate decisions. And third, our proposal for reaching an outcome in the final decision necessary to avoid serious degradation of the company's financial integrity. But first, I would like to draw your attention to the chart that we submitted in our introduction section of our written exceptions. This chart summarizes the financial impact of the decisions and the changes that we're recommending and that I'll be discussing today. We have copies here today. I just want to make sure, does everybody have a copy that wants one? Okay. To start, it is important for us to frame the point of view from which we are working. Everything that I will say today comes from the perspective that there is a gross misconception that the interests of the utilities and the interests of customers are somehow 2 completely different things. The draft decisions affect extraordinary, damaging outcomes, and the interests of customers are not served by these outcomes. The interests of customers are surely to have affordable rates, but those rates are in exchange for a service. The service is an essential service needed to provide energy to homes and businesses, to maintain public health and safety, and to support the Connecticut economy. These services come at a cost. The interests of customers and the broader public interest are served by having access to essential services at a reasonable cost. The interests of the utility are to have rates that are sufficient to cover the costs, including the capital costs necessary to preserve financial integrity of the utility, so that they can provide that service. The interests of customers and the utilities are locked together, like yin and yang. In this context, the cumulative impact of PURA's rate decisions matter. The cumulative impact cannot damage the financial integrity of a utility. Why? Because the utilities will not be able to provide essential services in Connecticut if they do not have adequate revenue to pay back their sources of capital. These utilities compete in a national market for debt and equity, and decisions like this are crippling the utilities in that regard. What is the end game here? Utilities can only provide the level of service that rates cover. There are no magic Jack and the Beanstalk beans that show up to cover the gap. There's no pot of gold that utilities are sitting on so they can provide service for free. It's money in and service out. That's the equation. All of these rate decisions do is create a downward spiral for customers to lower levels of service at higher costs. And just briefly, I would like to see why that is. Utility systems must be viewed as live organisms, like a huge garden that needs constant attention, weeding, expertise, and lots of water. Utility systems operate at high levels of performance 24 hours a day, 365 days a year. When utility resources are cut back, things that need to be done on the system pile up along with costs. When utilities have adequate and stable cash flows and cost recovery, they can plan and conduct work proactively. They can procure needed labor and materials under contracts that are cost-effective because their vendors can also plan accordingly and provide lower-cost services. When they don't have enough resources, they have to push work forward, where it gets done reactively, on a run-to-failure mode. When costs cannot be planned and managed with more lead time, costs are higher for customers. This just drives more rate cases, not fewer, more. This is the course we are all on. There is no end game. Once a utility system starts to decline, it is very hard and very expensive to get it back. Customers will have to endure a lower level of service and pay more. This is not utility noise, created because the utilities are greedy fiends serving shareholder interests. This is a fight to keep investment dollars flowing to Connecticut. This is a fight to protect the interests of customers now and in the future in maintaining safe, reliable, and adequate essential services to their doorstep. The job of this body is to balance the interests of customers and the utilities, not just to harm the utilities and call it a balance. It is the necessity of maintaining this balance that is recognized under U.S. constitutional law and state law principles. Our fundamental request in this proceeding and all other proceedings coming out of PURA is just process and outcomes. It's not about single commissioners. We are asking for predictability, which comes from following the law and setting rational standards routinely applied. And we are asking for balance, which comes from respect for the essential roles that utilities are fulfilling, along with fair and impartial decision-making. So now I would like to turn to the conduct of the proceeding briefly. Over the course of this docket, a serious issue has emerged that likely affects every docket that PURA has conducted over the past several years. It takes some thought to wrap one's mind around it. Through a series of motion rulings in this docket and responses to FOIA requests that the company posed starting last May 9th, because we could not get any information regarding PURA's internal procedures for EOE's participation in a rate case any other way, it was revealed to us by PURA's response to the FOIA that all procedural, evidentiary, and other intermediate rulings in a contested proceeding are issued by the presiding officer and are not delegated to the executive secretary. In this docket, that would include 118 motion rulings and 2 draft decisions. All of the procedural and substantive issues raised by the motion in this case were decided through a letter ruling signed by PURA's executive secretary. According to the presiding officer's ruling on motion number 118, the executive secretary's signature block is affixed to rulings of the authority as an enduring practice. Although here, according to the FOIA request, all of the rulings were actually issued by the presiding officer, not the authority. On its face, the fact that the presiding officer has issued all intermediate rulings might not trigger concern. Over Pura's history, it has at times functioned with a presiding officer who handled a proceeding from start to finish, subject to internal coordination in the confines of law. There is also a long history at Pura of the commission issuing rulings over the executive secretary's signature. Whether that's lawful or not may be debatable, but this has been the practice. Now, with the information disclosed in this docket, there is a significant difference in the lawfulness of Pura's procedures. In the past, three things were true. First, the commissioners shared the responsibility of dockets, even where a presiding officer was designated. The chairman was not the presiding officer on all dockets. Second, the executive secretary rulings were typically limited to ministerial rulings and did not set forth decisions on substantive issues or complex procedural matters before the agency. Third, when a presiding officer issued a decision, the parties and the public knew that it was a presiding officer ruling. It was clear and transparent. Rulings by the presiding officer were not issued using words that held out to the parties that the ruling was a decision by the full panel of commissioners, when in fact it was not. Why does this matter? It matters because the law requires Pura to be and to conduct itself as a multi-member agency, with each of its members participating transparently in the important decisions entrusted to it. The law requires that any matter coming before the authority is decided by a decision of the panel, which shall be the decision of the authority, and at least shall be approved by a majority vote, and that is section 16(2)(c). The law defines authority to mean public utilities regulatory authority. The law defines the term utility commissioner to mean a member of the Public Utilities Regulatory Authority. There is no individual commissioner, even if acting in the role of presiding officer, that constitutes the authority or the Public Utilities Regulatory Authority. The requirement to identify whether a ruling is that of the presiding officer as opposed to a decision by the authority is cemented by the fact that under Connecticut Statute 1-225, which is Connecticut's FOIA law, there must be a written record of the commission's vote on the matters addressed by the commission. Pura does not have any exception to the FOIA statute, and this provision of law states that the votes of each member of any such public agency upon any issue before such public agency shall be reduced to writing and made available for public inspection. Under the UAPA, the agency is defined as the commission. There's no provision of law that authorizes the chairman to designate herself as a presiding officer in every Pura docket, including this docket, and then to make what ends up being a decision of the agency in that role. In fact, this sort of arrangement was expressly written into law as part of SB 7 in the 2023 legislative session and then deleted in the implementer bill. So we know for a fact that there is no legislative authority for an arrangement where a single commissioner is making decisions on behalf of the authority or the Public Utilities Regulatory Authority. As a multi-member agency, Pura must act through all of its members subject to very narrow and carefully confined exceptions when a presiding or officer or hearing officer may act alone. The concept that a presiding officer would rule on all intermediary matters, basically everything between the filing and a final decision, is not supported by the UAPA. The term intermediate appears in the Connecticut UAPA under the definition of final decision, stating that a final decision does not include a preliminary or intermediate ruling or order of an agency. The agency is defined under UAPA as the commission authorized to make regulation or determine cases. Final decisions on a contested and uncontested proceedings are signed by Pura's commissioners, whether in a court or in dissent. With the signatures of the commissioners, these decisions constitute the record of the votes of the commissioners, meeting the requirements of Section 1-225. Without a record of the commissioners' votes on matters subject to their decision, there's no transparency as to the responsibility for various decisions rendered by Pura, which directly contradicts the purpose and intent of Connecticut's FOIA and open meeting provisions. The practice also has due process problems. Here, the company's due process rights in this proceeding have been prejudiced due to the unlawful procedure and abuse of discretion. Every ruling in this case, including substantive rulings on motion numbers 6, 14, 73, 76, 102, 115, 116, and 118, was issued under the false representation that it was a ruling of the authority. When issued in the name of the authority, the ruling cuts off a party's opportunity to present critical decisions to the full commission for review and to potentially obtain relief during the proceeding when it matters. Where the parties are led to think that the full commission has already ruled, the only opportunity for challenge is at the Superior Court when the entire case is on appeal after the decision. In footnote 2 of the presiding officer's ruling on motion numbers 118, the presiding officer asserts that if the companies believe they are prejudiced by a ruling of the presiding officer, they are free to raise the issue if and when they appeal Pura's final decision. However, this statement simply highlights and confirms the prejudice that has occurred with the false representations of authorship. The commission has the inherent, unalienable power to overrule a presiding officer, and the opportunity for that has passed by the time the final decision is issued. At that point, the potential for a party to obtain relief during the proceeding is cut off. Intermediate matters are a building block to the final decision. If the companies lose out on presenting evidence relevant to their case without the ability to have that evidence considered by the full panel, the ability to prevail in the final decision is inherently reduced.
Attorney Kimball, what recourse are you specifically seeking from the authority on this matter? I know that the company has 75 pages of briefing on this matter, and I imagine you're trying to preserve it for appeal, but we do have a lot to get through today on this substance, so I'm hoping that you can narrow this down to what recourse the companies are looking for at this time.
Well, I have a little bit more to go through, and it's not repeating what's in the written exceptions, and it does matter to this proceeding because I think we have to understand where the draft decisions are coming from. I will be then able to go through the recommendations that we have, but I just have a little more information to go.
Okay, I'm just recognizing that you did say briefly, and I do know we have questions. Speaking for myself, I have questions on the substance, so I'm hoping that we can have time
I'm going to
get
get there. Thank you so much. Thank you. It is also important to note that the presiding officer's ruling on motion number 118 alleges that for decades and across hundreds of proceedings, the companies have abided by such rulings and until now never noted or objected to the mundane custom of affixing the signature block. Over the past several years, the companies and other parties before Pura have, of course, abided by rulings of the authority because those rulings were held out as rulings of the authority. It is only now that we learn that the presiding officer has been issuing her own rulings using the executive secretary's signature block. This by no means is business as usual or a practice that the companies have acquiesced to, and it is clear that Pura's patterns of conduct have changed. For example, Connecticut Regulatory Council received an email on August 23rd, 2022 from General Counsel Muska, directing all Connecticut Regulatory Council to submit any filings requiring the approval of the authority as a motion and stating that the authority would review the motions and respond with an approval, denial, or other disposition. If the presiding officer in every docket is the chairman and all requests for approval from the authority and all dockets must be submitted as motion rulings, and the presiding officer rules on all intermediate decisions, including all motions, can it be assumed that all motions and all dockets across several years may have actually been issued by the presiding officer under the guise of the authority, simply using the executive secretary's signature block? Where has the full panel of commissioners been allowed to participate? How can we know if there's no records of the votes, no votes recorded, maintained, or made available to the public? Since receiving Pura's FOIA response on September 17th, 2024, we have researched Pura's dockets and determined that since January 1, 2020, approximately 5,000 motion rulings were issued using the executive secretary's signature block. Of that amount, approximately 1,000 of those rulings were substantive decisions, setting forth factual findings and legal conclusions of the authority and the Public Utilities Regulatory Authority. Less than 10 were signed by all three commissioners, or a majority thereof. These 5,000 rulings involve about 535 dockets with a broad range of parties, including utilities, solar developers, competitive suppliers, telecom providers, and others. The perspective that a single commissioner can affix the signature block of the executive secretary to a ruling without any record of whether any of the other two commissioners even know that the ruling is being issued defies explanation and calls into question the legality of every intermediate ruling issued under the signature block of the executive secretary over this time period. Each of those rulings across all of those dockets may have exceeded the authority of the presiding officer and is therefore potentially tainted as ultra-virus. Who is harmed when a single commissioner takes it upon oneself to decide all intermediate decisions? Basically everything from filing to final decision in all dockets, falsely holding out those decisions as those of the full authority. Certainly the companies are, but so are other parties, as well as the public, the press, the governor as appointing authority, and the legislature in its oversight role. All have an interest in Pura's members participating in matters entrusted to the agency and in having those matters decided in a transparent manner. What were these executive secretary rulings deciding? In this case, in our written exceptions, we outlined numerous rulings by the presiding officer that were legally flawed and that prevented the companies from obtaining relevant information and public records that should have been readily provided by the agency. Most of these rulings denied the company's request with the finding that the authority would not be using the information in making its final decision, which is an entirely inappropriate basis and begs the question as to how the presiding officer knew at that time that the information or evidence that the company was seeking would not be germane to the decision ultimately put before the three-person tribunal. Not one of the evidentiary rulings went in favor of the companies, even though all we were asking for was simple information to defend our case and to assure that there was a separation in fact between EOE and Pura. Collectively, but even individually, these actions raise very valid and serious concerns. I have personally never seen conduct like this in any other administrative proceeding I have ever done. There should have been a hearing or some other process to put the issue to rest, but that was not forthcoming. So now I will turn to the second area of concern, which is the decisional framework applied in these draft decisions. This is a proceeding resolving two rate applications that the companies filed on November 3rd, 2023. The rate applications were filed in response to a petition submitted to Pura on April 24th, 2023 by the Attorney General, OCC, EOE, and CIEC, requesting that Pura conduct a general rate hearing for CNG only. The petition did not pertain to SCG. The companies did not assert any opposition or any challenge to this request, and in fact, the companies readily committed to a rate review. The request to conduct a general rate hearing for CNG flowed from the fact that in calendar year 2022, CNG over-earned its authorized rate of return. At the time, its allowed rate of return was 9.3%, and CNG earned 11.07%. This equated to over-earning of about $5.6 million. Under the settlement agreement in place at the time, 50% of the over-earnings were returned to customers. With carrying charges, Pura required CNG to return approximately $4.2 million to customers, representing about 75% of the over-earnings. CNG did not over-earn in 2023. CNG also did not over-earn in first quarter 2024. In second quarter 2024, CNG reported an earned return. However, this number is not a calendar year number because ROE is reported quarterly on a rolling 12-month basis. SCG did not over-earn in any period. SCG's authorized rate of return was 9.25%. It has not exceeded that. The draft decisions are solving for a $5.6 million over earnings in 2022 for CNG with a $75 million rate reduction for CNG and SCG in 2024. If you don't believe my math, believe the math of Moody's, S&P, and now most recently Fitch, which are three of the largest credit rating agencies that rate the creditworthiness of utilities. Immediately following the issuance of the draft decision, S&P and Moody's were in touch with not only Avangrid, but also Eversource To both companies, S&P and Moody's expressed deep concern at the outcome projected in the draft decisions. Last week, they each took the unprecedented step of cutting the investment outlook for CNG and SCG to negative. This change in outlook is the last step that Moody's and S&P take before a full credit downgrade. This is not just noise. This is evidence of a massive failure in utility regulation in the state of Connecticut, which is setting the interests of customers and the state's economy back by a decade as compared to other New England states. Credit ratings are not just about debt. They are also about equity investment. A lower credit rating means a higher cost of debt, just like it means for an individual who tries to buy a car or a home. For the utilities, that higher cost of debt is spread across millions and millions of dollars of debt that utilities must use to cover their cash gaps. Unless substantial changes are made to the draft decisions, there will be a credit downgrade following the issuance of the final decisions, potentially not just for Avangrid, but also impacts for Eversource or other Connecticut utilities as well. The utility's ability to raise capital is being substantially impeded, and this is harming the interests of customers, which this body is supposed to be protecting. If someone is looking for noise to go away, issuing these two decisions on this record and after these procedural irregularities is not the way to do it. What exactly is PURA's obligation in a rate case to assure a utility's financial integrity? I can tell you what it is not. On April 17th, 2024, during this pending rate proceeding, Chairman Gillette published a dissent on PURA's interim decision in dockets 240103 and 240104, which were the Eversource 2024 annual revenue adjustment proceedings. In this dissent, Chairman Gillette states, as a regulator, I also understand that it is my duty to monitor and consider the financial condition of the utilities that I regulate. This description is not correct. In fact, Section 1619E of Connecticut law directs that PURA shall examine and regulate the establishment of rates in accordance with the following principles. Number 4, that the level and structure of rates be sufficient, but no more than sufficient to allow public service companies to cover their operating costs, including but not limited to capital costs, to attract needed capital and to maintain their financial integrity. The Connecticut Supreme Court has consistently held that the return to the equity owner should be sufficient to assure confidence in the financial integrity of the enterprise so as to maintain its credit and to attract capital. And for that, I refer to Connecticut Light and Power Company versus Department of Public Utility Control, 219 Connecticut 51. Therefore, it is not accurate that a public utility commissioner needs only to monitor and consider the financial condition of the utilities. The job of a public utility commissioner, even in Connecticut, is to objectively and judiciously balance the interests of utilities and customers, accepting that the primary customer interest is the public need for adequate, efficient, and reasonable service, not rate cuts, and that the primary utility interest is to maintain its financial integrity to obtain the capital resources necessary to provide that essential service. These are at the very core of what the agency is supposed to be deciding in this case. This is all over Connecticut law, including Section 1619, where PURA is required to consider whether the rates are just, reasonable, and adequate to enable such company to provide properly for the public convenience, necessity, and welfare. Importantly, before we start going through each of the separate adjustments, the draft decision fails to articulate any analysis or any explanation as to how the rates set in this decision will allow the companies to maintain their financial integrity as required by Section 1619 EA4. Moreover, the lack of any explanation or analysis of financial condition is notable. In the Aquarion appeal, PURA argued that the merits of Aquarion's claims turned on whether the company can maintain its financial integrity, and that the court should dismiss Aquarion's claims about financial integrity because PURA had conducted a stress test in the final decision to assure Aquarion's ability to maintain its credit quality. In the final decision, PURA had included elaborate discussion and analysis as to Aquarion's, quote, financial condition and flexibility at pages 28 to 31 of that decision. In this section, PURA purported to weigh multiple scenarios to ascertain what the potential impact of various ROEs would have on credit metrics. On appeal, PURA told the court that having performed the stress test, it was clear that the decision did not jeopardize the company's financial integrity. However, at oral argument, PURA had to admit that when it ran all of those scenarios during the case, it had not updated the test to analyze the total effect of the final decision, which was a rate reduction instead of a rate increase, as had been assumed in the scenarios. This is one of the issues now pending before the Connecticut Supreme Court in the Aquarion appeal, because when you do factor in the actual rate reduction, Aquarion failed its credit metrics, and Aquarion was downgraded in May 2024 following the issuance of the judge's decision in the Aquarion appeal. In United Illuminating case, which was decided August 2023, PURA included a section entitled Financial Impact, where it performed similar stress tests, purporting to evaluate the financial ratios reviewed by Moody's, S&P, and Fitch, and finding that the relevant credit ratios would stay within credit parameters. But once again, PURA failed to examine those ratios based on the actual results of the final decision, assuming in those scenarios that the requested $91 million rate increase would be granted. Instead, PURA granted $16 million. On September 4th, 2024, United Illuminating's credit outlook was reduced from stable to negative. A negative outlook in a credit rating signifies that there is a high probability of a rating downgrade in the near term. It is the last step before a credit downgrade occurs. If the draft decisions are issued without a change, a downgrade for UI is likely. On June 6, 2024, Chairman Gillette spoke before the CBIA, the Connecticut Business and Industry Association. There, she stated that in the course of a rate proceeding, we take evidence on all aspects of a company's economic health, financial health. We look at credit ratings and metrics under their current rates and what they could be moving forward, which is appropriate. But not here. In the draft decisions, all of the financial condition analysis looking at credit metrics is eliminated. There is no stress test, and there is no assessment of how these decisions will affect the financial integrity of the companies. The draft decisions don't even mention the fact that we took it upon ourselves in this case, after what we learned in Aquarion and UI, to run PURA's so-called stress test using OCC's recommended rate reductions. Keeping in mind that the rate reductions instituted by the draft decision are even more damaging than OCC suggested, our analysis showed in that discovery that following OCC's recommendation would result in a credit downgrade. We produced this evidence in RRU 428 for SCG and RRU 397 for CNG. However, this evidence is not mentioned anywhere in these 200-page orders. And we already know that Moody's and S&P, and most recently Fitch, have taken the extraordinary step of lowering the credit outlook for the companies based on the draft decisions. This is proof that the decisions are hugely damaging to the financial integrity of the companies and perhaps other utilities in Connecticut as well. Where does this leave us? Virtually no issue was raised in this case procedurally or substantively that was decided in favor of the company. There's mistake after mistake in the draft decisions, but if you're looking for as big of a reduction as you can find, then you're not second guessing the numbers when you come out with a big negative. So let's go through the checklist. One alternative for resolving this proceeding is to suspend the docket, conduct a process on the ex parte and bias concerns as should have occurred, and then proceed to a final decision once those issues are correctly resolved. This process would at least have the potential to remove the overlay of doubt, impropriety, and reprisal characterizing the draft decisions. A second alternative is for at least the majority of the commission to reach a final decision that is consistent with the fundamental obligation that the commission has to customers and to the utilities, which is to produce a balanced decision that results in just and reasonable rates that are sufficient to sustain the financial health of the companies. I stated up front that we prepared a chart that we submitted in the introduction section of our written exceptions. There are 3 categories of mistakes and disallowances on this chart. There is a subtotal that identifies the changes needed to maintain financial integrity. For CNG, the minimum to maintain financial integrity is a rate reduction of approximately $5 million as compared to our filed request of $19.7 million. For SCG, which never under-earned and has not under-earned through 2023 or 2024, this would be a rate increase of 18.1 as compared to the 43 million that we requested. To the best of the company's knowledge and expertise, if the rate decisions get to these rate recovery outcomes, a credit downgrade can be avoided. And I can back that up by the fact that both the S&P and Moody's rating notices actually listed the disallowances and amortizations that are causing the imminent downgrade. You will notice that these items are almost 100% aligned with what we have included in the major adjustments column, with a few exceptions that were not challenging. So you do not have to just take our word for it. To reach this level, -5 for CNG and 18 for SCG, it would be necessary to first correct $10 million of mistakes in the CNG decision and $24 million of errors in the SCG decision. This will be hard to do because the decision is very hard to figure out. We would like to propose to provide you with red line passages of those sections to help you get the math corrected. We can submit those red line passages by Monday of next week. We did not want to present those to you without your permission ahead of time. Second, it will be necessary to make adjustments to the cost of service as outlined in the chart. I'm happy to discuss any one of the line items with you in detail, and I have subject matter experts with me. All of the issues are discussed in detail in our written exceptions, but if I could beg your patience, I just quickly run through this checklist. If we start at the top with Pura's mistakes, the first one is only for SCG. And this is just, I'm going to try to put things very simply if you have, again, additional questions. This is a situation where we owe money to customers. When we pay that money back to customers, it reduces our tax expense. When the calculation was made as to how much our tax expense would be reduced, it was taken out twice. It's a double count of a reduction in tax expense. It's $10.2 million. That needs to get corrected. Number two is when you set rates, you have a revenue requirement. The revenue requirement is a set of costs. There's no revenues in the revenue requirement. Revenues come in when you're calculating a revenue deficiency because then you're matching your costs versus your revenues that are coming in. But when you're deciding an approved revenue requirement in a rate case, you don't have revenues in the revenue requirement. So this is a $3.4 million reduction for CNG and $2.8 million for SCG. It's just a line item called other revenue, and it's deducted from the cost of service. It doesn't explain what it is, and it's wrong because it's revenue. So that needs to get corrected. Number three is related to a couple things on this page. And this is complicated, but in my simple lawyer's mind, this is how I explain it. When a company makes capital additions, they are allowed to take depreciation expense as a tax deduction. When they take accelerated depreciation called repairs deduction, that is good for customers because it reduces rate base. It's an offset to rate base, so customers pay less. When you take that reduction, you get some credits, and customers got the benefit of those credits in the company's last rate case. But then the company couldn't use them. And so even though the credits flowed back to customers in the rate case, the company didn't get its benefits. So the customers benefited twice, reduced rate base and value of the credits and rates, but the company did not get to use those. So that creates an asset that needs to be recovered. So if we look at the very bottom line of this whole page, down at the bottom where it says expired FCIC, you'll see these very small amounts. $50,000 a year for CNG, $200,000 a year for SCG. That's like the tip of the iceberg. If you disallow those two amounts, you're actually disallowing the whole asset has to be written off, which is $20 million. Also, if you write that off, the companies stop taking the repairs deduction, which is a benefit to customers. So this is like a whole bunch of other decisions here where these decisions are like shave $1 here, but push it forward to customers in the future. $10 here, 100 million there. Like literally that's what this is. So we would simply ask that at the bottom, you put back the $50,000 to CNG, not a lot of money out of $30 million, and $200,000 for SCG. Then we don't have to write off the asset. Then we continue to keep taking the repairs deduction. Then customers get the benefit of that. This also shows up, this same kind of flip side issue shows up at the top under artificial credit. What this is this is the credit that would pertain to the rate year capital additions. So here what the PURA decision does is say, you cannot get, we're taking rate year capital out, you're not going to get that, but it still took the credits. But the credits come from spending that money. So they cannot be a deduction to the cost of service at the top. You can see it's a $3.7 million reduction for CNG, $6.3 million reduction for SCG. This is under artificial credit. You can't take the credit if you're not allowing the capital. Now, what we would propose to do, since the credit rating agencies are looking at this, and this is a huge issue for the utilities, is when we're trying to set rate year rates, what are we doing there? We come in with a test year cost of service. That's based on our actual books. It reflects all of our actual costs. That was 2022. Now we're trying to set rates for 2025, 2 years later. And the exercise is to try to set a representative rate that reflects what is expected as your cost of service. So of course the companies are going to have capital additions in the rate year. So you need to have some accounting for that in the rate year. Here, the interesting thing is that we quantified in the bottom section, we quantified that the rate year capital expenditures would cost customers $6 million a year for CNG, $10.4 million for SCG, but the credit that is up above that can't be taken if you're not allowing rate year capital now applies at the bottom. So you can see right underneath plant rate year capital expenditures, FCIC applies to reduce those capital expenditures. So the $6 million for CNG is $6 million minus $3.7 million. The 10.4 is minus 6.3. So when you put all these pieces together, you say, okay, here's the choice. We can put some rate year capital in. We can apply the credit so customers are paying less than half of what it's going to cost and have the rate set up to allow for some capital investment. Or we don't allow that credit and the company then has to stop taking the repairs deduction because it's not getting credited or given any benefit through rates. So it just doesn't seem like these pieces are being fit together. What should happen is, number one, you got to take the credit out of the top because that's just a one-sided credit. It doesn't exist. It's fictional. And what should happen at the bottom is to allow rate year capital expenditures in with the tax adjustment to diminish it, to reduce it. In the order, there's in the UI rate decision, rate year capital was disallowed. And we did not appeal that because it said there, it said, you didn't prove your burden. You didn't do this right. You didn't do that right. You didn't give us enough information. It was unreliable. It was not enough. So we came into this case thinking we will wipe the slate clean. We will take the advice. We will take the direction to double down and do a better job on all the documentation. We put in testimony, we put in exhibits, we put in everything that's needed to support the rate year capital. Now it's not getting rejected because we didn't file the information. Now the story is, well, you don't get it because it's not used and useful. We can't put stuff into rates which is used and useful, which doesn't make sense to me because PURA is at court saying, I have discretion. I can cut anything I want because I have discretion to make the rates be whatever I want. Well, if you have discretion to cut, you have discretion to put in. And used and useful is a factual finding, which means this body, as the agency, makes the factual finding about what is used and useful. And I just would remind people that customers do not pay for rate year capital on day one, that rates go into effect. Rates go into effect, whatever costs, you put $100 in rates, day one, they pay 1/12, 1/12, 1/12 through the year. So we knew that the commission is concerned about this used and useful. So we proposed to monitor and report and to true up any amount at the end so that customers were held harmless.
Attorney Kimball, it seems like we're leaving the FCIC issue for used and useful, and I have a question about FCIC.
Sure, go ahead, sure.
Okay, so do you read the draft decision as denying future recovery of the rate year expenses, or rather just not allowing recovery through the instant decision and rates?
So I know that the decision, I think what your question is, but correct me if I'm wrong. I think you're saying you can't recover it now, you can recover it later. Is that what you're saying?
I'm asking if that's your interpretation of the draft.
Yes, thank
Okay,
you.
so,
Sorry, go ahead.
oh, I'm sorry. I thought.
No,
the
you
question
go
answered. Okay, so my question on the FCIC as it pertains to the credit that would be taken for rate year expenditures. Given that interpretation of the draft decision, and it doesn't prevent the company from investing in capital throughout the rate year. The disconnect for me is why the company could not claim the FCIC now and seek recovery of the plant in the next rate case. I'm not sure why it's mismatched, because it feels like should the decision not capture the FCIC in this decision, that ratepayers would lose the credit and not be able to reclaim it in the next decision, while the company would be able to reclaim the expenses associated with the plant in the next decision. So that's the disconnect for me. if you
Okay,
could help.
so that's a great question. So thank you. So there's two aspects to that. When PURA says you're not going to recover it now, you'll recover it later. I would agree with you. You haven't found it imprudent. You haven't said it's imprudent. You're just saying next rate case, come back in. The problem for a utility is that once something goes into service, it's depreciating. So let's say the next rate case, the rates go into effect at least 2 years, 3 years from now. There's lost value because the depreciation is depreciating and lowering the value of the asset. So if you don't put it in rates today, then 3 years from now, that asset, you're not getting, that's lost. That's just lost to the company. So when PURA says you can recover it later, let's say it's worth $100 today, then when you come in, PURA only puts into rate base what the net book plant is at that time. So if the asset has depreciated from $100 to $70, we're only recovering $70 at that point. So you've lost $30. That means that this gets to the second part. That means if you don't allow future rate year capital in rates, they can't spend it. What utilities will do is they will spend what is in rates. If you give them the rate year capital and rates, they will spend it, they will invest it, they will come back to you and report and reconcile for customers to make sure customers pay no more and no less than what went in. And then they can have the credit. The problem with giving the credit and thinking that, oh, you're going to get recovery at some future point, they're not going to do the capital additions next year if it's not in rate year, and then there's no credit.
Okay, so I think that the situation you described is the, regulatory lag, and certainly we're not the only jurisdiction that does not allow future plant into rate base. So, I mean, the rest of the country, those utilities are still meeting their core obligations of investing in service and seeking recovery for that at the next
Yeah.
rate
I think
case.
one thing you're really overlooking there is, for instance, if we take Massachusetts, New Hampshire, Rhode Island, well, Rhode Island allows the rate year capital. Massachusetts operates off of numerous capital trackers. So they don't need, and they actually do now allow the first year roll in of rate base, because if you have trackers, then you can have a rate case. The rate case accounts for a certain level of capital that's historical, like you're saying, through the test year or a short period after that, as PURA has allowed, and that's much appreciated. But they have trackers. So you come out of a rate case. So you're talking about regulatory lag. They have trackers that immediately pick up that capital that's going on between rate cases. The gas companies don't have that here. They have limited DIMP, but
They
that's,
dim.
but that's been capped, and that only represents about 60% of their capital spending.
Okay, so thank you. Getting back to the FCIC though, so, is the FCIC available for the DIMP investment?
We will check on that.
Okay, thank you. So is the company's position kind of, saying back to you what I think I just heard, is the company's position that it's entitled to the FCIC rather than ratepayers in the situation that we have here, because the FCIC is offsetting the value, that the company is losing as it depreciates between now and the next rate case?
That's not what we're saying. We're saying it won't exist if we don't recover rate year capital and rates, because we can't spend the money if we don't get it in rates. So if you don't put rate year capital and rates, then there will be no FCIC because we won't be spending the money. That's the future part. The part down at the bottom, the expired FCIC, that's the going back part. That's a different issue. This is the going forward part, which is exactly matched. This number that you have, I believe, but we'll get checked from people, my experts behind me. But I believe the number that you have here for what we called the artificial credit, 3.7 million for CNG, 6.3 for SCG, that matches, that goes with the rate year capital.
Understood.
Okay.
So the company's position is then that it's not going to continue to invest in its system if the rates don't have forward-looking plant.
What we are saying is the capital investment has to be supported by rates. The company will spend what is allowed in rates, but the double whammy here you have to remember is that PURA has also reduced depreciation expense significantly. So let's just talk about that for 1 second, if you wouldn't mind, then we can come back to your question. I want to answer all your questions. Right now, coming into this case, both companies proposed a small increase to depreciation expense, which would imply an acceleration of depreciation, about $2 million a year for each. OCC proposed a downward increase. What we are asking you to do now is to just leave depreciation alone. Don't change it up, don't change it down, because the company's current spending is tied into that current level of depreciation. So when you take out of rates both the rate year capital and you cut depreciation so substantially, the business has to adjust its capital spending to match what's in rates, which will now only be reduced depreciation. So that's not going to be sufficient. So what's going to happen is they're going to come out of the rate case, they're going to file another rate case right away, because that's the only way to deal with that. And so what I'm asking you, because it's not bad for customers to have investment in rates. These are gas companies. They're hooked up to people's homes. You should want that investment. The best answer would be to leave depreciation exactly alone, provide that rate year capital, which is only half the cost is going to be experienced by customers because of that credit. So for the very small, relatively small amount that is in rates, it provides not only a huge benefit in terms of keeping the capital program going, but you can see that the rating agencies cite to those two things. The rate year capital and depreciation is the major items as to what is going to cause the credit downgrade. So there's the added benefit of avoiding the financial degradation.
Okay, I want to be clear that I did not see that because it's not part of the record, so.
What not part of the record?
The ratings downgrades that.
We
you're
filed
referencing.
them with our written exceptions.
Understood. The evidentiary record closed several months ago.
Well, that's okay because there's 118 rulings issued by the presiding officer under the name of the authority. So if we're talking about these little evidentiary things now, We put them in with our exceptions. I feel free to argue it at court.
Okay. So if I could go back to DEMP and finding out the answer as to
Mhm.
whether FCIC is available on DEMP. If we don't have.
They're checking. We'll have that momentarily. Thank
Okay.
you. Thank
And
you.
If I could ask, I just want to be really clear that I'm understanding the company's position on the investment going forward, because I had not understood that from the written exceptions, and I'm not sure I'm totally understanding what you're saying now. What I'm hearing is that the company is not going to invest in its system if the rate year capital is not allowed in rates. Is yes or no? Am I misrepresenting what you just?
Yes, you are.
Okay.
I said the company will invest what rates pay for. They're not going to invest what rates don't pay for.
Okay, I'm not trying to split hairs here, but I'm not clear on how
Sure.
that's different. So if the rates are not adjusted to reflect projected rate year expenditures
And depreciation.
and depreciation, so if the rates are not capturing that, then you're not going to invest.
They're going to invest up to the level that is captured by depreciation. It will be less than what they've been spending because they've been spending up to their depreciation allowance. But if you're going to cut the depreciation allowance, then the capital budget will have to be cut. They can only pay for what rates are going to pay for. If you don't put it in rates, you're saying to a utility, customers should not pay for this. Customers don't want this service. That's what you're saying. So utilities are going to respond to the signals you send in these rate orders. If you say, I will pay you, I will allow you to have enough funding for half your current depreciation expense, that's what the investment will happen up to that level. They have to see, they're going to follow your direction and they're going to follow what you put in rates.
Okay, so the company's last rate cases were, I believe, in 2017 and 2018 respectively, and had multi-year rate plans. So at the conclusion of those multi-year rate plans, did the company continue investing?
At the rate of depreciation.
Okay. All right, thank you.
So, Attorney Campbell, if I can just clarify, so my understanding of your explanation, your back and forth with the chair is without the FCIC credit, which provides a benefit if you invest up to your rates, but there's an opportunity to get a little more besides the rates because of that credit. And if you can't receive the credit or it's going to be reduced, the incentive to invest above and beyond the initial rates is diminished and consequently probably will bother at some point.
I think if you're saying, yes, I think the answer to that is yes. Yeah, they're going.
It's an incentive to invest more than you would have otherwise.
Correct.
Without it, you'll invest just what you have to and no more, no less.
That's exactly right, Commissioner. Thank you.
Thanks.
If I could just move on, there's just a couple more issues here and then I'll be done. I thought you might feel like this was a couple rounds of chemo and your hair hasn't fallen out yet. So I'm going to do two more little issues. The increased cost of debt from the latest issuance. In this case, the companies did a debt issuance during the case. It is increased cost because the credit ratings are down, the cost of debt is up. We put substantial evidence in. We put discovery during the case. We did rebuttal testimony. We described everything that happened. We put all that in. In the final decision, this increased cost of debt is disallowed, and it's disallowed on several different grounds. It's disallowed under this idea that somehow this is a change that required a rate amendment, which is not correct. So under PURA's regulations, there is provision for amending a rate request within 30 days. Typically, other states have the same kind of rule. And what that rule is really aimed at is that when a utility files a case, let's say I file a case like we did here, $43 million, we put notice out to customers. So once customers are noticed in a proceeding, the general rule is you can't have a revenue requirement be approved coming out the other end that is higher than what customers were noticed. So most all states have some type of rate amendment rule where you can come in within a short time and you can make adjustments upwards in case you have to make some adjustment and there could be a notice provision. But what generally happens through the case is there's all kinds of changes that come in up and down. But so long as the rates that are approved at the end are less than what the notice was at the beginning, then there's no rate amendment that is needed, because there's always, the whole idea of a rate case is there's things coming out, there's things going in, it's a year long, you're getting all information is happening, there's known and measurable adjustments. So that rate amendment provision is really used for protecting customers from on their notice of what their potential rate change may be. Because a utility comes in and asks for a higher rate of return than is normally allowed, there's normally like this play in the number that you can have ins and outs without ever exceeding that initial notice to customers. Customers are always going to end up, the rate in the end is always going to end up being lower than notice. I've really never seen an example where it's come out higher because of the changes that occur. So here, the order says that we should have made a rate adjustment because of this increased cost of debt when there's this is not a rate amendment issue. It also said we didn't put any evidence in, so it avoided saying anything about the evidence we did put in. And it said the only evidence we put in was in a late filed, and that's too late to bring it in. But that late filed that's referred to in the order did not pertain to the cost of debt. All of our information was in much earlier in the proceeding. So there's no reason this increased cost of debt shouldn't be in this cost. Also, there are past orders of the PURA saying that, hey, you know what? All these rate cuts may result in a credit downgrade, but you know what? The cost of that downgrade is cheaper for customers than all the cuts we're making, so we'll take it. So that's the deal that's been struck. We don't care if credit rating downgrades are happening. The cost of those downgrades are less than what we're cutting out of rates. So this cost needs to go in. It needs to be included in the cost of service. There's really no reason for it not to be in there. The two other last things, and then I'll be.
Before you go on,
Yes, sure.
go on,
Sure, sorry.
can I clarify this one as well? So in terms of when a applicant needs to put in that amendment, the 30-day motion, only if they are planning on increasing the initial rate request from the original application.
Normally,
get
that
that.
is what that provision is for. Yes, sir.
So if ultimately the rates were approved at 5% less than what you approved, the amendment is essentially unnecessary.
There's no
So,
amendment because it's all about customer notice. Customers can never pay a rate increase bigger than they were noticed
Right.
for
Okay, without the amendment.
without the amendment. Thank you.
Thank you.
Okay. Okay, so I'll take these a little bit out of order. Cybersecurity, we would just respectfully ask for that to go back in. This money is needed. One of the largest water utilities in the country just had a cyber attack. There's no reasoning in the decision as to why this is just coming out. It's just another cut to take out. This money is needed for cybersecurity. Can we please have it? We're just respectfully asking, can we have that back in the cost of service? Audit expense is $400,000 for each company. And the findings there are that audit expense benefits shareholders. So this is not true. A utility cannot go in, obtain long-term debt without audited financials. PURA has a requirement for FERC Form 2, audited. The audit function is important to all aspects of the utility operations. It's $400,000 a year. It's a small cost for the benefit. It is not a shareholder benefit. Please put that back in the cost of service. Also, lastly, inflation. So I talked a little bit ago about how we're taking a test year cost of service. We're trying to turn it into representative rates in the rate year. And so there's a 2-year gap there. So all utility commissions is part of the rate making function allow an inflation adjustment on residual expense, meaning that there are known and measurable adjustments. So for instance, labor, people have raises, people have incentive comp or whatever it is. Those are known and measurable changes because you can identify them. They're easy to, kind of discrete to see. But the inflation adjustment is not intended to be something that attaches to all these different kinds of things like contract escalators. It would never be feasible for a company to come in and be able to show inflation in every single function. The inflation adjustment doesn't pertain to individual items, because what will happen in reality after rates are set, some things, prices will go up higher, inflation adjustment, some things may be lower or not at all. That inflation adjustment is just intended to bring the test year forward to the rate year reasonably. Usually, what most states are looking at is, what is that inflator you're using? So are you using CPI, GDPPI, what are you using for the inflation? And we've had a lot of inflation. So a regulator could quite rightly say, inflation using these indexes has been 8.5%. We don't think customers, that's the right rate going forward for customers. We're expecting inflation to temper. So we're going to put a different rate in. That's the kind of adjustment that regulators make. And that's fair. That's within the discretion of the agency. Here, Connecticut Water just came in. They got the inflation adjustment on 30% of their O&M as the residual amount, the non-known and measurable amount. Here, the gas companies are asking for the inflation adjustment on 20% of their O&M, and yet that is 100% rejected. So one difficulty that we're all struggling with is the rules change every case. There's no rules. There isn't any rules. I hesitate to even use that word because the rate decision comes out, it's completely different. And all we hear is, we have the burden of proof. How do we meet a burden of proof? It's like a moving target all the time. And we don't even know what the target is till after the decision comes out. Then we try to follow it. We try to come into this case with documentation, trying to do everything that we were said wrong that we did in UI. Clean everything up, try harder on every single thing. And there's two $40 million rate reductions. 30 cuts across the board has nothing to do with evidence. Nothing. So what we're asking here is, can we have some reasoned judgment here, but case to case to case? And we're asking for the inflation adjustment on 20% of the O&M, and we think that should be restored. I think that's, the last one, one last one. You'll see on the bottom section, the SCG 10-year credit to customers. So this is money owed back to customers. And we proposed a 10-year flow back to customers because we were trying to be mindful of some cash flow restrictions. And so we looked at that and we proposed 10 years. Pura now has done it at 3 years. So that's too fast and it's causing a cash flow problem. What we would like to propose is that the money that's owed to customers took 6 years to accrue. So we are just asking, could you please just give it back in 6 years? That would match the time period. It's less than the 10 years we asked for, more than the 3 that you're giving. It eases the cash flow problem and it matches exactly the time period from when customers paid it in. And so.
Can I ask a question on
sure.
that? So I'm just trying to unpack and understand the cash flow issues. If the company is not disputing that this is a pot of money that it accrued from customers and that's owed to customers, was it not kept as a separate pot that's untouched that can be returned to customers tomorrow if it was asked. I mean, the
Okay.
company didn't,
But
wasn't.
that's like
entitled to
assuming
it.
that you have like a bank account somewhere where you literally have the dollars put aside.
Sure.
That's not how it works. This is all on the books. These are things on the books, right? The money is a pot of money that's flowing in and out. It's all fungible. You have money flowing in from rates. You have money flowing in from your lenders. You have money flowing in from any equity that you're picking up. It's going into a big pot. And so the pot is limited and you're paying all these things out. And the biggest thing is capital, because we have to remember if a company's spending 150 million on capital, all you're getting back, even if Pura allowed it, would be somewhere around $15 million a year. So there's a lot of cash flowing out. And so when a company proposes different amortizations, they're looking at how the overall pieces fit of the money flowing out of the pot that they have. And so one of the problems here is because you have so many other cuts going on, that you're diminishing the revenues that are flowing into that pot. So now it becomes harder to pay cash out.
Okay, I think I'm still not understanding because I think if the company knew from day one that it was over collecting from customers money that was always going to be returned from customers, it's not like 5 years in, we
Correct.
said
Yep.
the last 5 years, you had to look back.
Yeah.
So why was the money not being put aside from day one and treated and not treated as fungible, knowing that it was going to be owed to customers?
That's never how it happens.
Okay,
The money, any accounts that you have on your book, whether, think about it, if it's customers that owe the company, right? How do you set up aside money if customers owe it to you? And if it's money that you owe out, it's all on the books.
okay.
So now, to your point, which is a good one, like it's always important to be looking at giving customers back the money. Like I would like to mention that on the non-firm margins, that got decided in 2021. The companies wanted to give that money back right away. It was Pura that said defer it, put it aside, and now is trying to give it back over 3 years. And we're not disagreeing with that. We want to give that money back, non-firm margin back. We wanted to give it back 3 years ago. But now that we have different pots of money that you're trying to flow back all at once. And this means you have to start taking a look at how much money you're pushing out and when you're cutting everything coming in. It's just math.
Okay, thank you. I had a couple of questions on areas that you did not cover.
Sure.
And it sounded like you were wrapping up.
I think I skipped a couple of things, but please ask your questions. Maybe that will answer them.
Okay, thank you. Just a few narrow questions.
Sure.
So on the unused mains and services line filtering error, the written exception stated in part that the drafts included an error when filtering by the project ID. So, and I think internally the staff have run those calculations a couple of times and aren't able to replicate what the filtering error was. And in the draft, I'm sorry, in the written exceptions, it doesn't really expound other than to say filtering error. So I'm hoping you can
Yeah.
elaborate a little bit
Yes,
more.
I didn't mean to speak. Can I just check with
Please.
councils? Because I don't think we're protesting anything on what the ultimate decision was there. We might have said something in the written exceptions. May I just check?
Sure. Yes. I mean, the written exceptions I was quoting from speak to disallowances, but please.
Sure, I understand.
On this topic. Okay.
I think there's one data request where it appears that some rows are double counted in the equation. So Mr. Hurwitz is going to find that discovery request and I'll have him speak to it.
Thank you. And Mr. Hurwitz, if I understand, so the formula in the company's submitted data request double counts? No, okay.
May he approach?
Please.
My apologies. I do not remember.
You're just going to have to speak up. I'm sorry.
Okay. I don't recall the number of the data request in question. I think there were only a couple on the unused mains and services topic. One of them had some highlighted rows showing subtotals. And then the rows directly beneath that highlighting had like the itemized components adding up to those subtotals. It looked to us like the math included both the row summing the subtotals and the itemized pieces down below, if that makes sense.
Okay. Okay, thank you. I appreciate that. That's my narrow question on that. I have a few others, but Mr. Vice Chairman.
Attorney Kimball, earlier in your remarks, you mentioned that if there aren't some adjustments made in the proposed final decision, that there will be quote, a low level of service, and that ultimately the ratepayers would pay more. Could you just expand on that,
Sure, absolutely.
please?
So if we, just to keep it all very simple, if you assume that rates are associated with a level of service, whatever the costs are that a commission is allowing into rates, that is kind of identifying the level of service that customers are going to get associated with that recovery. So because that's really the message you're sending. You're really sending a message that says, we don't want you to spend any more. Like, this is all customers want to pay for. So what a utility will do then is going to adjust the service levels to that level of revenue, because that's the message you're sending. Now, does that mean they're not going to take care of fundamental obligations? There's probably every person in this room that works every day to meet a fundamental obligation. They will meet fundamental obligations. However, there's a big difference between meeting a fundamental obligation and kind of providing the higher level of service that customers might want. So what happens is, if you're going to keep cutting back on revenue, the service levels have to adjust to that. And so you keep doing that for a while, but it's like a garden. You know what I think of? I've been thinking about this. I know this is kind of stupid, but I think of, like, if you're in the basement of your house and you have a massive garden outside and you have water mains going outside and you have all these dials and you have a little wrench and you go around and you want to adjust every dial by 25%, 35% here, 50% there. Eventually, you got to go to look at the outside. Is the water coming out of the main? Because if the water coming out of the main is only 30% of what the garden needs, the garden will start declining. Does it mean that the whole thing's just going to fall apart? No. You still have some water going to it. It's going to adjust to the care and feeding that you give it. So what will happen for customers here is, as you keep cutting and cutting, you're cutting bone. You're not cutting fat here. There's no fat. You've cut depreciation. Nobody earns on depreciation. $5.5 million of over earnings, $75 million in cuts. I mean, come on. So you're going to have to reduce that cost of service to meet the level of revenues you have. That means this is not just like the roses in front of the steps. This is like everything out back is just starting to decline, and it's slow. And it's maybe even imperceptible to a regulator now. Maybe this is 4 years from now that all of a sudden the system needs more. I have seen this with a client I have that, let service quality go for a little while. It was an electric company, nobody here. And then their service quality metrics started showing it up. They weren't putting money in the right places. So they started getting penalties on the service quality. And now they had to go readjust their investment. They were investing in the system. They just weren't investing everything that the system needed to keep it up to top notch. And it took 10 years to bring that system back. It takes a lot of money. It takes a lot of time to bring a system back up to the levels that the companies were at before 2 or 3 years ago. And so it's declining. You have to understand that revenues and service are matched. And what's happening here with these rate decisions is that you're making decisions about saving a couple bucks here for customers, and customers 3-4 years from now, it's gonna all pile up and hit them where they have lower levels of service, rising costs, and they're paying the penalty for a few dollars here. So it doesn't make any sense. This is why I spent so much time on financial integrity. What is the end game here? What is the end game? What are you trying to accomplish? Because rate cuts may feel good. They're a brand. That's what they are, a brand. They're not a strategy for customers. And so it's time somebody has to stop this. Somebody has to say, this isn't good for customers. We're going to make sure that we're care and feeding that garden. Do we have to have massive rose bushes all the way through the garden? No, absolutely not. Not if people don't want to pay for it. But we got to have more than this.
Thank you very much.
I have a couple of more specific
Sure.
questions, please. On the incomplete approvals for interim plant additions, the companies argue that the projects within the approval program were authorized to proceed based on approvals of the individual work orders. And the written exceptions, as I understand them, cite to exhibit CIP-2. I'm hoping that maybe, like Mr. Hurwitz did on the last one, someone can point me specifically to where that is in the exhibit, because I've looked a couple of times, I'm struggling to find any delineation of individual work orders or that statement.
Okay, he's going to check. Thank
Okay,
you.
Thank
Thanks.
you. So my next specific question is on the low-income discount rate, LiDAR. I think the company has advanced a couple of different arguments around this during the proceeding, but my perception was that there was a new one in the written exceptions that I just want to make sure I understand. I understand the written exceptions to suggest that there's not currently any orders or tariff provisions that would allow for the recovery of LiDAR in those rates, and suggest that they can't, and that's I understood it to suggest that's a barrier to reconciliation in those mechanisms. I just wanted to unpack that a little bit
Sure.
more and understand, is there something in a final decision that the company is looking for to be allowed to make tariff changes to those? If you could just help me understand that.
Can I have Mr. Venora help here?
Sure.
Thank you.
Thank you. Yeah, Chair Gillette, I think that is an issue. I'm sorry, can you hear me okay?
Now I can.
That was a point that we raised in the written exceptions, that in those, the various rate component tariffs, that language doesn't exist there. But I think the bigger issue, and it's set out in the written exceptions, is the reasons why those mechanisms don't really lend themselves to do it, to recovering the revenue shortfall from the LiDAR discount. That was the primary.
Understood,
thrust there.
and understood that in the proceeding. I think I'm trying to get at the more narrow question of if the decision ultimately does pursue recovery of the LiDAR discounts through those mechanisms, is the company's position that the decision also needs to include some authorization that those tariffs for the underlying mechanisms, so DIMP, SER, CAM, PGA, et cetera, you need some kind of permission from the authority to alter those
Well,
tariffs?
I think it would need some direction, because none of those tariffs are in the case, right? Or, this is all just for the distribution tariffs, but I think we would need some direction from the authority on how to proceed, if that becomes the direction.
Okay, thank you. That answers my question. And if we're not ready to address the previous one yet, I can go to a vacancy factor question.
Mr. Hurwitz is checking. He'll have that answer in the minute, but
Okay.
I have been reminded by Mr. Venora that I missed just a couple of simple ones at the top. Could I just do those while we're waiting for that? Or do you have other questions?
I have
Sure, keep going.
at least one more question about the
Sure.
vacancy factor, if I could. So I understood the written exceptions to be comparing and contrasting the treatment of the vacancy factor here to the authority's decision in 220808. I want to unpack that
Sure.
a little bit. So am I understanding that the vacancy factor in 220808 from the company's position or recollection is that it only applies to the incremental FTEs? Do I have that right?
Mr. Hurwitz says that's what happened in 220808.
Thank you. So to follow on to that, the 220808 decision, does the company agree that it left intact the compensation based on the entirety of the vacancy factor, meaning that the vacancy factor dollars were undisturbed, even though the vacancy factor applied only to incremental FTEs? 'Cause that was my read of 220808, and I just want to make sure that I'm not missing something.
I'm going to let him explain, so we're not playing telephone.
Okay, thank you.
Without having reviewed the decision anew for this, that is not my recollection. If
In here.
that's,
I can't,
Mr. Hurl, can you use your microphone, please?
or just tip it up, maybe.
Thank you.
I did not review that decision anew for this. That's not my recollection. If that's what was done, we would have taken issue with that too.
You would or would not take issue?
We
with-
would take issue with that.
Okay. Okay. Thank you. I have a question around the ADIT amortization for SCG, which I think Attorney Kimball, you started, or was maybe at the top of your list, and I was not ready to interrupt at that time. So I'm just looking to better understand it, because the written exceptions present it as like a straightforward mathematical calculation, but there's no, I just need a little bit more
Yeah,
explanation, please.
I know exactly what you mean, because we struggled with this. Like, a lot of this is so complicated, and we really went through many iterations to try to figure out how to state it plainly. So the funny thing is, the written exceptions kind of come at it from a different way than the way I explained it. And the way I explained it, and again, we can have Mr. Hurwitz, but I explained it kind of like the flip side than what is in the written exceptions, which is just very simply, we're flowing money back to customers. That reduces our income tax expense. This adjustment is taking that reduction out twice. And that is the exact limit of my knowledge. So I want to make sure we answer your questions. So should I have Mr. Hurwitz address this? Also, I mentioned at the beginning, not to interrupt you, but we were hoping that we would have the opportunity by Monday, just on limited sections. This would be one of them. Could we provide you with some language that would correct just for you to review, accept, reject, whatever? But could we try to provide you with some language to correct the double deduction?
I mean, I think you're always free to file that attached to a motion for the consideration of this body. So,
Okay, thank you.
I'm not going to roll on the motion from the bench, but if I could have Mr. Hurwitz explain
Sure,
that a
of
little
course.
bit more, because I see the statement that okay, so the assertion is that the base revenue adjustment used to calculate the sit and the fit was overstated. That's where I'm overstated. Why, please?
And my apologies, we were researching your question about CIP2, so I want to make sure I understand the context. You're asking about the $10.2 million double count, the first line of the table? And why?
Well, maybe I'm not referring to the same thing. I was referring to what I thought was $12 million from page 60 of the written exceptions. There's a statement that the company, this is the amortization of the deferred income tax credits.
So as Attorney Kimball described, we struggled with this, and I'll just describe what I think gave rise to the circumstances we identified, and then I'll talk about how we tried to explain what we saw. One of the findings in the SCG draft decision moved the location of the amortization from where we had put it, the regulatory asset and liability schedule, to the income tax schedule. And on its face, that's fine. You can put the money anywhere you please, but formulaically within the model, the first couple of lines of that income tax schedule reference all of the other schedules within the model, and they use that to compute income tax expense at current rates. So it looks to us like when this was deleted from the regulatory asset and liability line and then added below on the income tax schedule, that we inadvertently, or the draft decision inadvertently removes the tax effect because you've deleted it from the regulatory asset and liability schedule, and it's no longer picked up in the introduction of the income tax schedule. It appears to us that it was inserted lower down in the income tax schedule, and by extension, you've missed the income tax effect of this amortization.
Okay,
So
Okay.
and
thank
we
you.
tried to show this a couple different ways. I think the table you're referencing shows another sort of angle where we tried to make this clear that in the amount of income tax expense reflected in the SEG draft decision, there's just not enough income tax to go around. There's credit for income tax expense, which is not usual, but in this case, conceptually okay, because there are significant amortizations that SCG is giving to customers. There are a couple of tax amortizations at FCIC, but we tried to show mathematically that the size of the credit in the SCG draft decision is far too large. And we think this is the reason, but without the work papers to see what the best we can offer is an educated guess.
Okay, I appreciate that. Thank you. That answers my question on that. So I have the two outstanding questions, but let me.
Thank you.
So in the written exceptions on page, I think it's 149, 145. The companies tries to show the effect on their ultimate ROE based on the current draft decision. Would you mind going back through that for me a little bit?
Sure.
So essentially, you're all saying, regardless what the ROE is, we could post a 10.2 as requested. You're not going to reach it according to what you provide in the written exceptions.
Yeah, so thank you so much for asking that, because in trying to cut down my already extensive comments, I kind of took that part out. I think that's why I went over financial integrity so much, because in this decision, you will notice we are not arguing about ROE or capital structure. The draft decision gives a clean capital structure ROE, and thank you for that. The problem is that number 9.2, you could make it 18.2. It does not matter, because you're like, remember my water example with all the dials? If you say that the system is capable of 20 gallons a minute, but you turn off every valve, it's not producing 20 gallons a minute. It really matters how all these things add up. And so you make 9.2% ROE, it is associated with a dollar amount. Let's say, for instance, you take 9.2% and you multiply it times rate base, and it says, okay, we're going to put a factor into rates that's $35 million a year of earnings. That's how much these companies are each earning, somewhere around $30 million or the low 30s. So let's say you put that into rates, $30 million, but then you put that in as a line item. Here's your earnings. But then you cut everything, 30 cuts, capital, depreciation, everything. Well, you can't earn that. You can't earn that $35 million. That money, just like an allowance at home or a paycheck, that paycheck is going to pay for every other expense that's not covered in rates. So you can't earn the 35 million that's in rates, because you're using the money for other, you have to use that to cover these expenses that rates is not covering. So the standard is not just setting a reasonable return, but setting rates in their totality that produce a reasonable opportunity to earn that return. And here, with all the cuts, you're not going to earn anywhere near that. You're not going to earn a fraction of that. The 9.2 almost becomes meaningless, because no company earns, typically you're not earning, at or above your ROE. Something is going on if that is happening, because the cost pressures are so high. So that's part of being a utility. And there's no guarantee, right? You're not giving anybody a guarantee of 9.2%, but you're setting rates that produce like 3 or 4 or 5%. Like all that's going to happen is we leave tomorrow, we take the decision, we're getting ready to file again. Going to file and file and file because there's not enough money to live on for the system.
So if I can use a household analogy.
Yes,
Similar to yours. So if I'm, you got a family that's making, it says, their straight salary is $100,000 and they think, oh, instead of one vacation, we can take 4 vacations, but they didn't account for tax deductions, insurance deductions, or 401k deductions, incidental deductions they weren't expecting. They don't actually make $100,000. It's
correct,
significantly less. And next thing you know, there's no vacation.
correct.
Okay.
That's it.
Okay. Thank you.
Thank you.
Okay, do we have the
Yes.
answers to the 2 questions?
I have the answer to the DIMP question. And
Please.
this is from our tax expert. He says, well, of course, he has to start with tax rules are complicated. But if we take that out, it says after that, this is a 5% reduction for certain eligible investments, including some DIMP investment. We believe that some aspects of DIMP investment are likely eligible for FCIC, but we note that the companies require taxable income to take advantage of the credits, which will not occur here under the draft decisions.
Will not get taxable income
In
from the
order to
DIMP.
take a tax credit, you have to have enough income to take the credit. But the draft decisions don't provide any income, so there's no credits.
Okay,
And I think what we could do, what we could offer to you also is that if some part of the decision here is making sure that whatever tax credits are associated with the level of capital, I think I could go out on a limb and say we would be willing to work with you to make sure the tax credit matches available recovery. Yes, I can say that.
can you restate that, please?
Sure. We would like to make sure that if you allow this capital cost recovery, which is so important to us, we will work with you to make sure that we have quantified all the credits that customers should get associated with the capital cost recovery you've granted. And we can produce information for you and we can make sure the credit matches, including DIMP. It just should match. It's a matching principle.
Okay, thank you. And the answer to the question about the exhibit CIP 2? That was my second question about incomplete approvals.
We would like to keep working on it and expecting others to talk. We'll be able to answer, we hope, by then.
Okay, thank you.
I just have to quickly mention, I'm sorry to do this, but just to finish the list, just so that we have said it. You've already asked about the vacancy rate. I think all we were suggesting here is there's a $2 million reduction for each company. I think we just want to do the UI, right, Jacob? Yes, we would just like to follow the UI model. If that would be possible, we'd just like to stick to that same standard. There's a item here at the top that's called double counts adjustment for ARO, reducing rate base. So ARO is an asset retirement obligation. It has to do with retired plant, and it's not supposed to be in rate base. We agree it has to be taken out. We came into the case and we took it out. We took it out of the beginning balance. What the order does is the order goes back to the last rate case and takes it out of that balance and then uses that balance. So it's taken out twice. We already had taken it out. The order's taking it out again. So it just needs to go back in one time.
Understood.
The last one is asymmetrical treatment is this. PURA used to have a standard of if you had regulatory assets and liabilities, you included them in rate base. And because there's carrying charges associated with regulatory assets and liabilities. So you put them in rate base and then the carrying charge from rate base applies. However, when you put them in rate base, it's locked in at a certain point of time. So these are amortizations. So they're amortizing and unwinding, and the carrying charges change. So when you lock them in rate base, they're just locked in at a point in time. So Pura has done a good thing. Get them out of rate base. Let's move them out. Most states have them out. That's the right thing to do. But here, what happened was there's a group of regulatory assets, which those are things that are amortizing that the company's collecting and getting carrying charges on. Then there's regulatory liabilities. Those are things that go to customers. Those are amortizing and we're paying customers the carrying charge. So Pura came along and said, we're moving things out. We moved out regulatory assets, so the company will get its carrying costs outside of rate base, and we moved out some small customer liabilities. We'll take those out, but the one big customer liability, we left in. We left in something that's somewhere around 56 million, which means that it locks in the carrying charges for customers. So all we're asking again and again, can we please have standards that are reasonably, routinely applied? If you want everything out of rate base, take everything out of rate base. Why is one thing staying in? Because somehow customers will get more carrying charges if it stays in. When every other thing is moving out, including other customer liabilities and other assets. So this is just one, if you want to do this policy, just please apply it in a routine and symmetrical fashion. Take this thing out of rate base, put it with the other regulatory assets and liabilities, and let it run with the proper standard you have now identified. Okay? Okay, I think I've covered everything on the list. So I'll sit down so other people can talk.
Thank you. Attorney Wheel? Okay. Consumer Counsel Coleman, good afternoon.
Good afternoon, Chair Gillette and Commissioner Karen. I'd like to just provide some opening remarks before Attorney Wheel addresses some of the arguments heard today. Though we'll be incorporating a few responses to some of the assertions heard by Attorney Kimball. At the outset, I do want to say I agree with the sentiment Attorney Kimball expressed that there is some alignment between utility and customer interests. When our utilities are proactive, strategic, innovative, and cost-effective, customers definitely benefit. But it's this cost-effectiveness piece, which is where Pura has a statutory authority or statutory obligation to ensure that customers are paying no more than sufficient to be able to achieve this quality and reliability. And what Ms. Kimball did not acknowledge is that utilities like CNG, SCG, who are and their parent companies have a fiduciary duty to shareholders to generate earnings and revenues for the shareholders, not for customers. So there is a tension. While our missions are in many ways aligned, the financial motivations are not. And that's where our office, the Office of Consumer Counsel, comes in. It's our statutory responsibility to comb through the books and records and to make a recommendation about the level of revenues that are sufficient, but not more than sufficient for the provision of quality of service. So it's with this statutory framework where OCC disagrees with the company's position that the proposed revenue requirements set will not result in rates that are just or reasonable, or that it would harm customers by undermining the company's financial integrity. I do want to be very clear that my team and I at the OCC would never support a rate decrease unless we were confident it could be managed by the company while still enabling the provision of safe, reliable utility service, even innovative service, which is what we want, and as we believe is the case here, particularly with respect to CNG. A lot of emphasis has been placed on the revenue decreases proposed. So I just wanted to take a moment to give a fuller picture of some of the considerations we considered. With the proposed revenue requirement, ratepayers are still responsible for paying both companies over $400 million annually, plus an additional $100,000 in executive compensation upon achievement of certain performance targets. So this is a significant amount of revenue we're talking about. There are also some specific and perhaps unique reasons why the companies need less, not more revenues to fund their companies, which are supported through the evidence. And some of them have been touched upon by Attorney Kimball, but I think it's important to think of them holistically together to understand the context for why, we proposed rate cuts and believe they're justified. First, as Attorney Kimball recognized, CNG was over-earning in 2022, meaning their revenues were far greater than actually needed to provide service, and that's what triggered this review. I don't think that's in dispute today. We have been monitoring their quarterly reports. The most recent ones filed August 5th, 2024, show a combined net income for the trailing the prior 12 months of 70 million. About 31 million for SCG and 38 million for CNG. So it does seem reasonable to us to draw the inference that with rate increases, they would, there's significant risk of continued over-earning. And that's particularly true with respect to downward trends those same filings are showing with respect to operating expenses, which I believe Attorney Wheel will touch on with a little more detail. The second driver here is in the difference between the company's rate applications and the draft decision is that the Distribution Integrity Management Program, we've all been referring to as DIMP, which funds the pipe and service line replacement, will remain outside base rates and recovered through a separate mechanism, a tracker, as we've all called it. And this tracker will essentially operate as a surcharge on bills, and that will better ensure that costs and rates are aligned. And it will directly fund the safety and reliability measures that we have heard concerns about. The proposed caps on spending intentionally protect ratepayers and are reasonable. In fact, they are based on a thorough review of OCC's expert who conducted what's called a leak rate analysis to ensure safety and reliability. And I want to point out that our expert looked at CNG spend and found current level of DIMP was higher than necessary and therefore recommended reductions. But for SCG, he actually testified and recommended, and we recommended through briefing that they need more money, demonstrating that this recommendation was not just an attempt to slash rates for the sake of slashing rates, but was rather a very careful, deliberate determination based on need and what is needed to maintain safety and prevent leaks. Third, while SCG wasn't over-earning like CNG, they were, as has been recognized here, sitting on a lot of ratepayer money that needed to be returned. This included about the $70 million in over-collected tax revenues resulting from the Trump administration corporate income tax reductions, which, as acknowledged already, had been accruing on SCG's books for about a decade. The company's proposal to pay that back over 10 years was not fair to customers. And I hear Attorney Kimball offering a 6-year return. We still don't think that is fair to customers, and we believe the 3 years is quite reasonable. And in fact, we were just looking up, and Attorney Wheel might help me out later, but I believe that for UI, those monies were returned in 20 months. So we would expect that CNG and SCG could do the same. Similarly, as has been acknowledged, both companies owed ratepayers money for non-firm margin, which is the extra revenue for off-system sales of unused capacity. This was incremental funding given to the companies for the gas expansion plan. But with the wind down of the plan, as ordered by PURA, it has been sitting on the company's books as a regulatory liability. So PURA properly ordered the companies to return that money through a credit to the distribution rate. And any incremental new non-firm margin will be credited back to ratepayers on an annual basis. So think, between the taxes and the non-firm margin, this is a significant amount of money that needs to come back to customers. And PURA rightfully ordered CNG to pay that back. So while the proposed cuts have been characterized as unjust and punitive, we do believe they're warranted to align the company's revenues with expected cost of service. The fact is that the company's current rate plans are both expired and were ripe for review under 1619A. And the purpose of that statute is to make sure that rates are continuously updated to remain current with the standards of the statute. And that is what, Pura's analysis is intended to accomplish, is to ensure that we are meeting those standards. Finally, I did want to address the concerns of the CNG-SCG unionized workforce, and I recognize that there are a lot of hardworking employees here that work hard to ensure reliable gas service. My team and I at the OCC do greatly appreciate all that work. We know that reliable service could not be provided without that work. And our positions in this case are aimed at right-sizing CNG-SCG's budget to reflect the costs that customers should be paying for according with the legal standards. And our statutory mission requires nothing less. But we do recognize the union employees' value, and we have tried to recommend and incorporate, reflect that value in some of the recommendations in the decision. For example, by supporting recovery for the proposed annual performance award incentive compensation for unionized workers. We found this was appropriate because the metrics directly related to service that customers benefit from. And the authority did adopt that recommendation, which we appreciate. So I do just want to thank the authority and the authority staff. I know you have all been working as hard as my team has over the last 365 days. And I do want to acknowledge my staff and reiterate that they have approached this case really methodically and really with an eye towards recommending rates that will be sufficient, but no more than sufficient as the statutory framework requires and in service to our statutory mission. So with the chair's permission, I will turn the mic over to our Director of Legal and Regulatory, Tom Wheel, for a few additional responses.
Good afternoon. I'm gonna be a little scattered because I kind of had to haphazardly write stuff while I was sitting next to Bruce McDermott, who was trying to look at my paper the whole time. I wanted to start with, there were a couple of assertions this morning that CNG hasn't been over-earning. I recognize that the company, I guess, is taking the perspective that over-earnings only count when they occur in the fourth quarter on a report. Not sure we agree with that. Every one of these reports is a trailing 12 months. So all of this data reflects the previous 12 months of data. So with that, if the authority is free to review the record, the last, I think, 10 years of quarterly earnings reports are in the record as OCC 691 and OCC 687. And just off the top, in the time I had kind of looking at my phone back there, I was able to verify that in Q3 2023, Q2 2023, Q1 2023, and Q2 2022, SCG did in fact earn above its authorized level of ROE. Also in Q4 2021, SCG over-earned and that was an annual over-earning, and they did have to share 50% of that over-earnings with customers. So generally, we disagree with this notion that it's only been CNG over-earning. Consumer Counsel Coleman already addressed the proposal for the tax credit. I would just add that our recommendation for that to be amortized over 3 years was actually out of consideration. We agree with the company generally at the notion of there being a matching principle. And the reason we arrived at the 3-year amortization period is that that's the proposed amortization period for all of the regulatory assets that are flowing the other way. So when the company is being paid back for external costs recovered through a regulatory asset via amortization expense, it's expecting to get paid that back over a 3-year period. So the matching principle should suggest that customers get that same amount, well, not the same amount, a substantially greater amount paid back to them over the same time period. I just wanted to point out, we've been trying to be reasonable and agree with the company generally as to the matching principle throughout the case. One example is the authority might recall our initial position on cash working capital was to remove non-cash items only. In fact, that was generally our final position as well, but the company throughout this case pointed out that we had inadvertently not identified some non-cash items that flowed the other way. And ultimately, our final position was that we agreed that the exclusion of all non-cash items, whether they benefit the company or ratepayers, whether the exclusion thereof benefits ratepayers or the company, makes sense to us. So I don't understand why the tax credit is different. I heard the explanation about cash flow. I think Connecticut ratepayers would be astonished to learn that more than $70 million of their money that the company's been sitting on for years is not immediately available to be paid back to them. I think that that's an expectation of them when it comes to paying their bills. And I'm personally surprised to hear that this money apparently just isn't there. And the company, I guess, needs time to kind of work it up. As Consumer Counsel Coleman noted, the UI settlement across a number of cases did include a provision where UI returned the same, it was a different amount, but the same regulatory liability over a 20-month period. We understand that that was a settlement. We understand that it wasn't in a rate case. There are differences there, but that does seem to cut against this notion that there's no way for this company to get the money together over a 3-year period, and they require 7 years in order to manage the cash flow concern. There was some discussion of inflation, and Consumer Counsel Coleman referenced this briefly in her remarks. I did just want to put a finer point on it. We've been reviewing both companies' reported operating expenses as reported in those quarterly annual reports that, again, are available in OCC 691 and OCC 687. And if you look at operating expense across the 10 years of those reports and start around 2020, in fact, the fourth quarter of 2020, you'll see a trend where those operating expenses steadily rise. And that's not surprising to anyone who's survived the last 5+ years. Likely the effect of the pandemic, supply chain shortages, and general inflation. But you'll also find that trend peaks for both companies in exactly the same point in time, which is the fourth quarter of 2022, and that those costs have steadily decreased since that time. And importantly, just as a reminder, 2022 Q4 was the same quarter where where both companies earned very healthy returns. In fact, CNG over-earned in that quarter, which is why we filed the petition in this case, and SCG earned exactly its authorized rate of return. So in this time period, the absolute height, according to the record, of inflation, where the entire country was trying to figure out how to make ends meet, was the same moment when these companies were at some of their healthiest moments in the last decade. And I think that just, again, emphasizes that a rate decrease is not absurd or uncalled for or crazy here. There was that discussion about how disallowances of rate year plant, the disallowances of rate year plant here mean that the company won't invest above the level supported in rates. I heard the chairman's reference to regulatory lag. I had the same thought. That's my understanding, is that traditional rate making principles, that's kind of baked into the model, the idea that you don't get contemporaneous, instantaneous recovery of your capital investments, that you incur that extra cost, that gap that Attorney Kimball was referencing, and that's kind of a stand-in for risk, because at some point these companies do need to incur some level of risk. I also just wanted to point out that I think if the authority looked back throughout the recent history, I think, of rate cases here in Connecticut, maybe over the last 15-20 years, I guess it doesn't matter how much history you look at, you would find that this commission has treated the question of forecasted future plant additions in rates differently across the gamut. And I think my understanding, having only been here for a few years, but looking back at historical rate cases, is that it depends on the facts and circumstances of the case before the authority, that there isn't a standard that any individual company is guaranteed to recover future plant investments. But and particularly, it's my understanding that water companies, for example, don't ever get future plant included in rates. But somehow, I think you'll also find that historically, I think if you look back through those same rate case decisions, you'll see that companies somehow manage to spend above the authorized level of plant from their last rate plan time and time again. They do find ways to invest above the level that's supported in their revenues. And in fact, you don't need to look very far to find an example of that, because you'll find it in this very case. Because if you look, and you can reference our initial testimony filed in this case, that the level of plant for both of these companies in the interim period was higher than the level authorized in their prior rate plans. And I want to be careful to emphasize that's not a problem. We're not suggesting that they overspent their allowed level, or and that's an issue. I do want to emphasize that plant should be and was, that we believe in this case, subject to prudency review. But it cuts against this notion, in my mind at least, that we can't, as a state, expect these companies to make investments if they're not getting instantaneous recovery of those investments. And it kind of also opens a broader question of, if these companies can't make investments without getting instantaneous cash flow, why are we paying a return on capital? Like, what is the capital for? What are the companies? I thought the whole model here was that we're paying them to go get money to invest on our behalf, and then we pay them back over a lengthier time period. And that brings me to a note I wanted to make about cybersecurity, about the master plan capital investment that's proposed. We very seriously acknowledge and agree with the importance of cybersecurity at this time. And I think you might have noted in our exceptions that we actually suggested that the O&M associated with cybersecurity should probably be reconsidered. And we would maybe make the same suggestion as to that plant investment, if not for the fact that the record seems to indicate that it won't enter service, not only within the record in this case, but outside of the rate year. It's not going to enter service until 2027 outside. So it's not even forecasted plant that would make sense to put into a future rate plan. And that is, despite our acceptance of the importance of those kinds of investment, it's just a bridge too far for us to follow in terms of rate making. One potential solution, though, that the authority could consider, and to which OCC wouldn't object, would be to treat that investment as a regulatory asset, as a deferral, to encourage the company to make the investment subject to a prudence review in their next rate case, and with recovery to follow after that rate case.
Attorney Will, can I ask, I have a question on the cybersecurity piece, and you may have just answered it with your suggestion about the regulatory asset, but I think what struck me when I saw your written exceptions around the recommendation for the O&M for the cyber was, what assurances would the authority have that money, which the draft decision finds was not shown to be a known measurable expense, what assurances would the authority have that money is actually spent on cybersecurity? Because I think elsewhere in this decision, we're setting rates back based on a snapshot in time, and see that, for example, the FTEs authorized in the previous rate case were not ever filled, meaning that the company had that money to do something else with. So this is, given that the departure from the test year expenditure on the cybersecurity piece in particular is so drastic, what assurances would the authority have on behalf of ratepayers that money would actually go to cybersecurity? Is that the regulatory asset suggestion?
It could be. The suggestion for the regulatory asset was specific to the capital, to the master plan, being that from our perspective, there is no other way in our mind that we would find acceptable for ratepayers to pay for that. There is no way we'd find acceptable for ratepayers to begin paying now for something that won't be in service until 2027. But I was suggesting the regulatory asset treatment as to that, as a notion that perhaps that would help the company feel more confident that there'd at least be a future discussion about recovery of that. I think, though, that I appreciate very much the question, and I think the answer is there is no assurance that any O&M in base rates will be devoted to any cost that the company or anyone else has proposed that it be devoted to. And that is also baked into the model. That's also something that's, at least as I understand it, just part of the way base rates work. And I think we've talked about this a little bit in the PBR context. Obviously, not everyone has been involved in those conversations here, but the idea is that you develop a revenue requirement as close you can, as best you can, to match what exactly to the letter, as close as possible, to match what you expect the company to incur in the future. But then there is no check back. There is no way to ensure that in that future rate year that those expenses will actually be incurred, or that that revenue will be spent on the things that you're targeting, as long as it's in base rates. So I think the answer to the chairman's question, where you need to have some sort of reconciling mechanism, that would be the only way to ensure that that level of O&M would be devoted to what it's targeting. That does, of course, I think the reason that the risk is baked into the model, that the uncertainty is baked into the model, is that that's supposed to be, as we talk about in the PBR context all the time, a stand-in for cost efficiency, a stand-in for the incentive to control costs. And that if there's too much certainty that whatever is spent in a particular category will be recovered, so long as it's proven that it was spent in that category, then you can potentially lose some of that cost, the incentive to control costs. So it would, I think, off the cuff, having not thought about it before you asked, it might make sense to consider a regulatory asset that's capped perhaps at the level of expense that's proposed by the company, if the authority finds that the record is sufficient to justify that level of expense, but then to have a reconciling mechanism, reconcile in the next proceeding to ensure that the expenses were spent on cybersecurity.
Thank you, Attorney Wheel. But is this not just a simple known and measurable issue? I mean, the program, as I understand it, according to the record, is not in effect. The draft decision makes some findings that the record lacks justification that these are known and measurable expenses. Why would we depart from the well-established precedent of a known and measurable change to include an expense and instead go with reconciling mechanism here? Is it simply because of the importance of the issue?
Yes, I think the answer to the question is that the authority wouldn't have to depart from that standard. It isn't OCC's position, and I hope it didn't come across in the exceptions, that there is, from our perspective, a legal issue with the current treatment, with the draft decision's treatment of those expenses. We agree that
There is or is not?
is not.
Okay.
If the authority has found in its discretion that the evidence doesn't support that those expenses are a reasonable known and measurable adjustment from the test year, then we do not believe that there's a legal problem with that. But the question is whether the authority, this maybe is getting back to something Attorney Kimball was referencing before, maybe looking at it from a slightly different way, whether the authority chooses to exercise its discretion to allow for an exception to that standard, which I think it legally can, for a policy consideration for something, if the authority decides that there's an important policy reason to depart from traditional rate making rules to make a specific exception for a particular expense, I think it could. So again, I hope that's clear. It's not my position that the authority should or must depart from the known and measurable standard, only that we would find it reasonable for the authority to exercise its discretion to do that for the policy reason of the importance of cybersecurity.
Does that, in your mind, create an unpredictable environment in terms of the situations in which we would or would not exercise our discretion?
It could, certainly. I mean, I think that cuts both ways as well. I think if there's a complaint that there's ambiguity as to the expectations of rate making treatment, then the more exceptions from the standardized rate making treatment the authority makes, the more potentially volatile that misunderstanding becomes. I think that would be a legitimate consideration from the authority if it were to consider departing from any kind of standard. I had two more things I wanted to address. There was this discussion of the draft decisions crippling the company's access to capital. And there was also this discussion about a risk for a credit impact. To be very clear, in case Consumer Counsel Coleman didn't already cover this, we recognize that lower credit ratings are not a good thing. That lower credit generally is not a good thing. That is, lower credit ratings or negative credit outlook, neither of which are a good thing for the company and ultimately not a good thing for customers because it will eventually increase the cost of capital. But we also have to recognize the reality that, at least from our perspective, whenever a company's revenue goes down, as we believe is necessary in this case because of the factors we've already discussed, there is likely eventually going to be an impact to the cost of capital. The capital markets are going to respond to a reduction in cash flow for a company. That's a reality. So a concern about a potential for an increase to the cost of capital can't mean that revenue can't go down, because that would mean that revenue can only ever go up. And if that's the scenario, then what authority does PURA have over any of the entities that it regulates? The statutory and regulatory framework that requires PURA to determine that revenue is no more than sufficient for the company to recover its costs, requires that PURA consider certainly the financial viability of the company, but at some point has to accept that it can't follow its statutory mandate in some circumstances if its only choice is to not reduce revenues or to not adjust a particular cost because Wall Street or credit rating agencies might not like that. And that seems to be the crux of the company's concern. We understand that investors would prefer that the company earn as much money as possible, but to suggest that this authority should ignore the legal requirements for cost recovery analysis in order to appease the capital markets, it misconstrues and negates the entire concept of economic regulation. We also recognize that, like I said before, credit downgrades do eventually increase the cost of debt. I say eventually because, of course, it's not instantaneous. It takes until revenues are adjusted and for that cost of debt. I suppose it's more instantaneous from the company's side, but the cost of debt to customers can eventually be reflected in the future in some future rate case. But it's unreasonable in our estimation to compare the scope of that eventual upward rate pressure, to the extent it occurs, to the substantial relief that would be provided by these draft decisions. I think Attorney Kimball was perhaps jokingly getting at this point before, that one could look at the potential increase of cost of debt and compare it to the reduction in revenue. And we have, and I think it's important to look at that in terms of scope. For example, even if CNG's cost of long-term debt increased by 200 basis points over what's in the draft decision now, if you just run that through the WACC calculation, the overall rate of return would increase by about 90 basis points, which would result in a revenue impact, at least as to the direct cost of debt, of a little less than $5 million. And that's a lot of money, but it's less money than $38 million, which is the revenue reduction that purportedly would cause that kind of reaction. And just to give a sense of scope, if you do the same thing on 1,000 basis points, it still does not, it's still over $10 million less. It would increase the cost of debt over $10 million less than the overall revenue reduction in this case. Again, I want to be really clear. We're not suggesting that the cost of debt should be jacked up to meet the level of revenue reduction that we're seeing here, but the perspective and scope is important. It isn't enough to just say this is going to cost ratepayers more in this category, because what's not true is that it ultimately is going to cost ratepayers more to lower overall revenues. We also have a lot of trouble accepting the notion that the draft decisions will substantially harm the company's ability to access equity capital, because the record in this case shows that the companies have not found it necessary to access very much equity capital over the past 20 years, especially as compared to the total amount paid by ratepayers for the cost of that equity capital. As we explained in our brief, the companies have accessed a combined total of $276 million in equity capital from the market over the past 2 decades. And over that same period of time, customers combined, the company's combined reported total earnings equal $870 million. From our perspective, that's like paying $870 million in interest on a loan for $276 million, because the principal on that loan is recovered through depreciation expense. So to the extent that a reduction in net income does increase the cost of debt, it's hard to imagine that the costs that we've already paid for equity, it's an issue of scope. It's hard to imagine that the massive cost that Connecticut ratepayers have overpaid, in my estimation, for the cost of equity over the past 2 decades would be anywhere near the scope of a potential increase in debt costs. The last thing I wanted to address is the company raised in their exceptions. I didn't hear it discussed today, but there's an exception. There's a suggestion that the company should be paid carrying costs on DIMP spend that exceeds the allowed caps. OCC didn't address this in our exceptions because we agreed with the treatment in the draft decisions, but we very much disagree with that assertion by the companies. The exceptions, as I understand them, refer back to the company's positions on carrying costs for deferrals. We don't see the spending cap on DIMP as being a deferral. This is not flowing through to amortization expense. There is no true up. Our understanding of the way that the DIMP spend is treated in the draft decisions is that overages above the cap would be treated just like any other capital expenditure, any other investment in plant, in that it can be sought for recovery in the next rate case and enter rate base. That's the way our understanding of the way the ESI works for Eversource. It's the way the WICO works. So we see no reason why the companies should be paid carrying costs on the DIMP budget overages, which, kind of getting back to what the chairman was asking about before, from our perspective, is an exception. That the DIMP, allowing the companies to recover DIMP on a surcharge, is an exception that allows them to combat a little bit against the regulatory lag we were discussing before. And it seems to us that the company is now reaching, saying this exception isn't good enough for us. We need to be made whole above and beyond this generous exception that ratepayers are funding. And unless the authority has any further questions, I'm all done.
All set. Thank you, Attorney Wheel.
Thank you.
Thank you. EOE.
Good afternoon, Madam Chair, Mr. Vice Chair, Commissioner Karen. This will be very brief. I wanted to say thank you to the authority for its careful consideration of the voluminous record and filings in this, or I should say these proceedings. I also want to thank my staff for their tremendous work in these proceedings. I think EOE did a fine job in helping the authority develop the record. I also want to thank all the other parties in this proceeding today. So that is all I have, unless you have questions for me.
No questions. Thank you.
Thank you very much.
Attorney Wright.
Thank you. Is that good for the volume? Okay. Thank you, Chairman Gillette, Vice Chairman Bukowski, Commissioner Karen. Thank you and your staff especially for all the careful and attentive work you put into the draft. It's very clear you spent a lot of time on it. I'm not going to echo the comments of the Office of Consumer Counsel or EOE, but I share their thoughts and we agree with them. This was a voluminous proceeding, the exceptions in particular, so something like 238 pages. It's a lot to digest in just a few days. But an awful lot of it, as you see, is sort of standard utility boilerplate text telling you about things that are just and reasonable, or that the company has to attract capital and maintain its financial integrity. And obviously nobody's going to disagree with that. But at the same time, it's really platitudinal. We all are against something terrible like the plague, and we can all agree about that. But that's not the job of the utility to come here today. The point is the company have to show and convince you that what in fact your rulings have violated these rules and the principles of rate making. And I don't think they've done that. Not just that they disagree with the rulings, but in fact that your rulings somehow undermine their financial integrity other than their say-so. I'd like to break the exceptions down to two basic categories. The first are the disagreements with Pura's substantive decisions, disallowances from rate base, cost of capital analysis, depreciation issues. And the second broad category, unfortunately, consists of attacks on the PURA's integrity. And we would like to address that so that on the record for this inevitable appeal, there will be the position of the Attorney General on some of those allegations. But let's start with what's familiar, the company's actual objections to specific PURA rulings and decisions. Sorry for garbling that out. In the chart provided, the updated chart provided on Monday, detailing the tables of different calculations that the company presented, that was helpful. They had three broad areas: the mathematical areas, errors, computational errors, major adjustments that they believe should be reversed, and other more minor adjustments. I'd just like to start with the mathematical and computational errors. They've identified quite a lot of math errors that they claim should be reversed. This should be non-controversial. Math errors in general, that is. Everybody makes errors in math errors, especially in such a large and complexly interrelated accounting proceeding. I've certainly made my share of errors on things like that. I know PURA is going to carefully examine these claimed errors, as you should, and as you always have done. Every final decision reflects changes that the companies have properly brought to the attention of the authority. And that's appropriate, and I expect you'll do that here. I do want to provide some context to the scale of the mathematical errors. According to the revised table, the PURA staff made computational errors that totaled more than $33 million for both companies. That's a mind-boggling number. It's large. And especially for the talented staff that you have to have made errors of that size. But nonetheless, I trust you'll give it the appropriate attention that it deserves, and they'll be treated fairly, as you have treated all of the utilities fairly under your regulation. Throughout the oral argument and in the written exceptions, the utilities have used somewhat apocalyptic language about what these decisions that you've made have will mean to the company. And for example, or just one example, the companies protested their authorized return of equity on 9.2%, which they declared on page 67 would unreasonably reduce allowed ROEs. The company's authorized ROE is the highest that the authority has awarded in the past 6 years. It's the same as Connecticut Water, decided this year. It's higher than the 8.8% to UI, higher than the 8.7% to Aquarium. And it's mere 5 basis points lower than CLMP and 10 basis points lower than Yankee Gas that were decided in 2018. This is not conclusion of animosity or evidence of bias against the companies, quite the contrary. The bulk of the argument today presented by the companies, and this is going to be the less pleasant of the part of the oral argument, is the remainder of the company's exceptions openly attack the character and integrity of the authority, the integrity of its staff, the bias of its presiding officer, false representations of the presiding officer, ex parte communications by the presiding officer and its staff, and that the providing officer inappropriately withheld records that were subject to public disclosure. The company has made very serious allegations, and we submit that these serious allegations were made on the most pretextual and manufactured evidence. They're disingenuous. I don't want to go too deep into the construction of these claims of improper conduct, for that would dignify them with a greater attention than they deserve. But I did want to bring up a few of the ones that were prominent. First is the false representations. The company alleges that the presiding officer made a false representation in their orders that the executive secretary had issued many of the decisions on the rulings, the motions rulings. The company cite CGS 16.2 to support that any matter brought before the authority must be voted on by a majority of the commissioners. In other words, the companies would have every single motion or every schedule change or everything else that the authority does under its name have to have a vote of 3 commissioners. Having an executive secretary, as the companies acknowledged today, issue rulings on motions and orders has been the practice in this PURA for the 25 years that I've been here. I've never heard of any complaint like this before. Moreover, the number of motions entertained in this petition alone was 116, I believe, if not more. If that required a full commission to vote on each and every one of those rulings, that would really gum up the authority's ability to complete this case in a timely manner, bring it to a grinding halt. It's just not a serious argument. And yet the companies darkly suggest that this is an improper falsehood intended somehow to harm the companies. During oral argument, counsel argued that the falsehood was that the presiding officer was making the decision in all of those motions, each and every one of them. At the same time, they believe that the executive secretary had been ruling on all of those motions all the time, and it was not transparent that the presiding officer was doing so. But apparently they had no problem with the executive secretary alone ruling on all of those motions and all of those objections. I just don't see the logic behind it. Next, ex parte communications. Companies say documented ex parte communications have occurred between the presiding officer and PURA staff members. Once again, it's becoming a familiar tactic for virtually all the company's arguments. They recite a litany of textbook boilerplate case law about the evils of ex parte communications, and then they follow it up with factual disclosures that amount to a nothing burger. They refer to a discussion during the hearings on the utility's obligation to serve new customers. Company's witness referred to a portion of the PURA's website, public information section on customer rights and responsibilities. Subsequently, after an internal deliberation, PURA amended the public information section to better reflect his current understanding of his obligation to serve. That's all agreed by everybody. But the companies now characterize that as an improper ex parte communication intended to undermine their legal and factual arguments. That's an absurd allegation on many different levels. First, it's not an issue of fact or law before the proceeding. It was not briefed by any of the parties. It was not mentioned in the draft. The statement on the public information website is not in any way legally binding on PURA. It's not a statute or a regulation. It's public outreach and education. PURA is welcome to change its customer outreach and education at any time it wishes without CNG or SCG's consent. Are the companies really claiming they deserved a seat at the table to litigate PURA's approach to their education pronouncements? It's nonsense. But more importantly, this nonsense has turned into an attack on the credibility and character not only of the presiding officer, but the attorneys and director of EOE. Your staff, EOE, worked very hard and effectively throughout this proceeding. They deserve better than that. Companies argue a persistent bias that the presiding officer has showed throughout this proceeding. They cite volumes of precedent to say bias is bad, again. But pressed to offer what that bias is, they cite a news interview in March 2023, where the presiding officer was quoted as saying, "Think what you saw coming out of the Pura just this last week. We were exercised a lot of those tools in the context of a water rate proceeding. This was really my attempt to show, as a chief regulator of the state, what I could do when given the opportunity to go through a rate case with a lot of these utilities." That is beyond silly. That would mean you are biased against all utilities under all circumstances, and that's just not supported by the evidence. That's not what you bring up to say the presiding officer is biased. The remainder of the allegations of bias are simply that somehow all the rulings that they felt strongly that they should have prevailed on didn't go their way. That's not bias either. I had a few other minor details, but I'd be happy to entertain any questions you may have, or if you had any further thoughts that you wanted me to go further on. Otherwise, I thank you very much for the opportunity to speak.
Thank you, Attorney Wright.
Thank you, Attorney Wright. Last but not least, Attorney Lon.
Thank you. Good afternoon, Chair Gillette, Vice Chair Betkowski, and Commissioner Karen. Again, I'm Shannon Lon. I'm counsel for Conservation Law Foundation. And initially wanted to note that we very much appreciate the authority's efforts to ensure that the company's customers pay just and reasonable rates. And in particular, we want to recognize that the proposed rate decreases will reduce customers' bills. This outcome is especially important for low and moderate income customers who are really struggling with high energy costs. And many people did raise this concern in public hearings and comments in this docket. In addition, we have a few suggestions for the authority to consider that would clarify and strengthen certain aspects of the decision that relate to climate change. First, there is increasingly widespread recognition in Connecticut and in other states of the need to align gas system investments and planning with state climate law. This issue was discussed extensively in this proceeding, in public comments, in the evidentiary hearings, and in briefing. And regulatory action from the authority is warranted because the companies are not currently incorporating state climate targets under the Global Warming Solutions Act into their decision-making processes. So as a reasonable next step, we're respectfully requesting that the final decision recognize the need for proceedings to align gas system investments and planning with state climate law. Secondly, we appreciate that in Order 13 for CNG and Order 14 for SCG, the authority is requiring the companies to annually submit data that relates to their environmental, social, and governance, or ESG, and their greenhouse gas reduction goals. The disclosure of this data would increase transparency around the company's climate and sustainability efforts. It would also better enable the authority and stakeholders to understand how the companies are measuring progress towards their goals. But as currently drafted, the order does contain a few gaps. For example, it doesn't explicitly require the companies to disclose their ESG or their greenhouse gas reduction goals. It only explicitly requires disclosure of data that relates to the company's goals. In addition, the order does not require the companies to explain how their goals and greenhouse gas reductions would contribute to meeting state climate targets. So requiring the companies to report this additional information would better allow regulators and the public to track the company's progress and hold them accountable in meeting their own goals and contributing to state climate goals. Finally, in Order 33 for CNG and Order 37 for SCG, these orders concern information that the companies must include in their next rate cases. And subparts A and E of these orders would require the companies to include the impact of greenhouse gas reductions in preparing their 5-year capital investment plans and in calculating their depreciation accruals. As written, the language in these two subparts is somewhat ambiguous. So it's not entirely clear how greenhouse gas reductions in themselves would affect the company's capital planning. We suggest that it is really greenhouse gas reduction targets that are relevant here. And for this reason, we suggest that subparts A and E of these orders require the companies to address the impact of greenhouse gas reduction targets under state climate law. And finally, we would encourage you to consider including a statement in the final decision that consistency with state climate law, the Global Warming Solutions Act, will be included in the prudency review for the company's next rate case. The companies have repeatedly said in this proceeding that they do not intend to take actions that are consistent with state climate law in the absence of regulatory direction. So a statement from the authority would provide that direction by explicitly informing the companies that they must start taking state climate targets into account in their capital planning and investments. Such direction would encourage the companies to take a more forward-looking approach rather than continued inaction. Thank you very much. That concludes our recommendation, and very much appreciate the opportunity to participate.
Thank you. Questions? All right, no questions. Thank you.
Thank you.
Okay, that brings us to the end, I believe. 1, 2, 3, 4, 5. Okay, I'm missing an answer to an earlier question as my outstanding item. Attorney Kimball, is there a response to that question? And I'm happy to re-ask it if needed.
May I just respond briefly to a couple of points, then Mr. Venora has the answer.
Yes, and I do mean briefly,
Yes,
please.
I'm not going to belabor anything. I very much appreciate the comments of both OCC and AG. So this is a good debate. People gave me leeway, so I'm not going to go back. So just a couple of quick things. I do just want to make sure I clarify what our position is on the presiding officer rulings. Because Mr. Wright, the esteemed Mr. Wright, said every motion cannot be decided by the commission, and we agree with that. We're not suggesting that. What we are suggesting that is the use of executive secretary rulings may have been fine in the past. They were fairly ministerial. They weren't for every single decision. Like, nobody saw a problem in the past. I think the problem now is only that in the end, there really isn't any statutory basis for the secretary signature block. There is a requirement under the law to know the votes. So if the presiding officer is making rulings, and I agree with Mr. Wright, like, it doesn't make sense to have the commission ruling on anything. Clearly, a presiding officer has some room, to make rulings. But you have to say it's the presiding officer because there's other things that flow from that. So no, we are not asking that every motion be decided by the commission. We're asking just to have transparency. If the presiding officer is ruling, just say that. Don't use the Gaudiosi signature block. And I think another thing which the commission did do actually on the RAM decision in August is if you're going to use the Gaudiosi ruling, just state. You got to state like who's the votes, like who's supporting it. You can't just have the presiding officer issuing rulings under the name of Gaudiosi, or sorry, the executive secretary, when the executive secretary signature block is associated with the authority, which is 3 people. That's all. Transparency. That's all we're asking for. I just want to say quickly about ex parte because our claims are not false and this will all get sorted out in court. If I ever thought about a commissioner in any other state asking a question, the minute the commissioner asks the question, that's an issue of fact or law in the case. As soon as the commissioner asks the question, the decision maker asks a question of the witness, what about this or that? That's now an issue of fact or law in the case. So the thing that was alarming here and is watching as we went through, and Dan and I, we worked together, is seeing kind of how things progressed. And we held back. We held back for quite a while, just trying to figure out like what's happening here. But then we kept being told there's a firewall. For instance, I just want to go back to say the first thing we asked for, just benignly, can we please know, for purposes of confidentiality, who are the people assigned to EOE for the purposes of this? EOE was nice enough to agree, we'll give them the list. But in response, we'll give the list. Here's the ruling. No, you don't get it. You don't get the list of people that are assigned to EOE to this docket. Why? And the ruling is it's not a necessity, like for who? And so okay, we move on. We ask, and this goes on, I'm not going to go through it. I don't want to go back. The problem is that then we get to a point where we're told the whole time there's this firewall. Then we get to a point, putting aside the whole removal of the webpage, put that aside. We get to a point where we find out within seconds, minutes, whatever, there's a communication from the person asking the question from the bench to EOE, a party. And the proper resolution, as Mr. Wright kind of alluded to correctly, is what you would do if there was an ex parte and about whether or not there was a legal basis for this customer bill of rights, is you put it out to the parties. That's how ex parte is dealt with everywhere else. Like, that's what cures it. If there's an ex parte, you put it out to the docket, you give other people the chance, cured. So, but instead, at every turn, there's just a refusal to address the issues. And so that's, these are not tactics. These are responding to the process that's unfolding in front of us. And then you get to July 2nd, when public documents that under 4-167(2), which says, any documents that the agency has, written statements of policy or interpretations adopted or used by the agency in the discharge of its functions and all form and instructions. We asked, what are the rules? If you have this big firewall with EOE, what's the rules between EOE and in a proceeding? We asked this throughout the proceeding. We're denied for all kinds of crazy reasons. And then on July 2nd, the day after we file our brief, lo and behold, there's a FOIA production. And when 4-167(2) says stuff like this has to be provided upon request, months before, during the proceeding. So all I am suggesting, and this is hard to raise, but we just want to be fair. We want it to be fair and transparent. That's what we're asking for. And rule after rule, law after law just gets blown through, and then we're the bad guys bringing it up. That's all I'm going to say on that. We'll deal with that at court. The other thing I just want to say, and thank you very much to Commissioner Coleman, I think there is agreement on this important point, which I'm very grateful to hear. Rates need to be sufficient, but no more than sufficient to cover operating costs and provide the opportunity to earn a reasonable return. So we agree that that's the standard. I think the problem the commission has right now, how do you know what is sufficient? You can't go through an order, just cut, and then go sufficient. There has to be a measure of where it all ends up. Where that is either, there's two ways to look at it. There's earned return, and Commissioner Karen, you and I talked about, there's looking at the earned return. There's looking at the credit rating. Those are two ways to know whether rates are sufficient. And maybe there needs to be, maybe the stress test version isn't even so bad, but you got to run it on the final decision and see what that does. Because if you're going to do this, you need some measure of how to tell, if we all agree that the standard is sufficient, but no more than sufficient, how do we know that? Then I just want to go back to Chairman Gillette. I don't know if you remember, but the last oral argument, you asked me a really good question, which was, are you suggesting, Counselor, that I'm supposed to approve cost recovery just because it meets cash flow metrics, even if I think the cost is not allowable, which is a good question. And I don't exactly remember my answer, but I've thought about that a lot since then. And I think that the issue is, I think I said to you, no, a regulator is not approving things on cash flow. That's not a standard. What the regulator is looking at is cost recovery and the ability to earn a return. So where you're reasonable about the cost recovery, the cash flow comes with it. And I think this goes back to having, if you're going to go down this path, and I say this to all of the parties, if we want to go down this path, we need to develop a way, some metric for understanding what is sufficient. Because we do agree on the standard, but we don't agree on how to show it. And without some rubric, you're looking at earned return and credit rating, and those are failing. Lastly, I just want to say I totally agree with OCC that capital cost recovery is not instantaneous. It shouldn't be. There's a principle of regulatory lag. It's almost impossible to be instantaneous. It's not a goal. What I want to say, though, in New England, every other state either does the forecasted rate year or they have a tracker. Here in Connecticut, you want to cut depreciation, you want to cut rate year, you don't want trackers. So it doesn't work. The other thing about managed to spend above capital allowances the last time, the companies came out of a settlement with OCC that was good and supportive for several years. If you have a rate paradigm that is supportive, then you can help, then you can spend more, you can do more, but you can't do that. So that rate settlement was supportive enough to allow that. You can't do that with these kinds of cuts. And one last thing, we did the third category here. I just want to bring this to your attention. This has $20 million of cuts for each company here. These are things we did not add into this number here, the -5 million for CNG and 18 for SCG. These are $20 million of cuts that we did put into our written exceptions, and we wrote why we thought they were wrong. We did not include them in the number. We'll go to court depending on the decision, but we are not asking you to restore $20 million of cuts for each company. We are trying to get to that minimum financial level, which is what is sufficient. The last issue, I think that might be it. I just want to go back lastly to this cost of debt thing. When the computation of $5 million, I don't understand. I'm not sure that's right. We can have a debate a different day, but in this case, we showed that they did a $60 million debt issuance and the increased cost was $2 million. So I don't know exactly how we're getting to damage of $5 million when just $60 million of debt costs $2 million. We also have to understand these are 10 and 15-year debentures. So once you pay more, you pay every year for 10 or 15 years. The impacts here are lasting. And that's just part of what I want to say. So I think Dan Venora has the rest of the answer, and I thank you for your indulgence.
Thank you, Attorney Venora. If I can have the answer to my question so we can wrap this up, please.
Yes, sure. Thank you. So I checked with our business people on this one. Your question, Chair Gillette, related to the reference on page 28, I think, of the written exceptions. And in terms of the so-called incomplete project approvals, and we had put a footnote or a reference there to CIP2, which was the Avangrid capital planning process. That, as we look at it now, the intention there was to be referencing the portion of the planning process that allows for modifications to project approvals. It's not explicit in there in terms of work order changes. The work orders themselves are shown in CIP, exhibit CIP-4. That's where they would show the work orders. And, so I apologize for any confusion around that. But that's where that's the citation should have also included CIP-4 and probably said it's consistent with the planning process, but it's not explicit in terms of the work order changes.
Okay, thank you. All right, I think that wraps us up. So we will take oral arguments and written exceptions under advisement. I believe we're scheduled to vote on a final decision in this matter on Monday, November 18th at 10 a.m. Thank you. We're adjourned.